It's a mandate matter.
Mr. Counsel, the order has not been uploaded, you know.
No, not uploaded.
It has not been uploaded, and in the meanwhile, there is a development that the view which we had taken, contrary view has been taken by Supreme Court in one of the cases. So that is the reason why we are going to post that matter again. We will re-hear, and then we are bound by the Supreme Court's decision. So that we will do. So please wait for that matter to be reheard. All right.
Early listing.
There is no requirement. Let that matter be decided first.
I may be pardoned to make a mention from today's board, Milots. From today's board, item 6 of additional supplemental list, ARBP of 29 of 2024. Revolving with the same issue of section 29A, there has been a subsequent development by the Honorable Supreme Court. We want to withdraw it today, Milots. If your lordships take it up at 2 o'clock, Milots.
We will take up.
Milots, due to paucity of time, there are 200 cases. Your lordship has taken 290 cases of
290 cases, those cases are formal.
And for that reason, I have mentioned, Milots.
Most of the cases are formal. Like the old matter. Infructuous. Which matter? How many?
Vote and item 6.
72. Only 72. One case. One case.
I will give the. I have 5 cases now. I do that 3 cases are infectious. I will give this sleep.
3 cases. And 2 cases are alive. 2 cases are alive. Give the.
So, we maybe make a mention. That's the least lawsuits now, even if it's 500, we don't have problem. But only request is that if the list is not for the file is notified on Tuesday, so that we can take out the file and intimate the authority to get the instruction of that.
We will next time.
Next 2 weeks, we can also be kind enough to notify on Tuesday and give us the list so that we can check together.
Even on Monday, it can be given.
Nice. So that representation can also be segregated.
Suggestion.
Old matter item number 1.
The compliance affidavit, they have rejected my case.
I'm success.
Matters.
It is stated at the bar that this contempt application has become infectious. And this court order has been compacted. Yes.
Item number 2.
In item number 2, Lordship, I have misplaced the brief, Your Lordship, and so also I don't have any instruction. So, liberty will be given if it doesn't survive.
States that he does not have any instruction to press this contempt application. Contempt application is the contempt proceeding stands stop accordingly as not pressed.
Lordship, can I pray for liberty to be given in case of any cause of action survives?
Where is the cause of action? 2006, we are in 2024. We'll see later.
As Lordship, please.
Item number 3.
I am for the respondent, Lord. In that case, I have complied the order of the Honorable Court.
Item number 4.
I mean, also item number 4, it has become infructuous.
Yes.
I am on virtual mode, Milots.
Yes. Yes.
Item
I'm SD Das, senior advocate.
Yes.
Oblige, Milots.
Item 5.
Item 5, my lord, I am for the petitioner. The petitioner voluntarily retired in 2001, due not paid. So,
Milots, the fact is the company has now gone on liquidation. Official liquidator is the liquidator of the company. Okay. Now they can lodge any claim before the liquidator. Nothing is now in our hands.
But we received a letter from company office that no liquidator has been.
Yes. official liquidator of the Odisha High Court has been, I think, appointed as liquidator.
My lord,
The liquidator has been appointed, he is saying.
here is a letter. Colonel.
But anyway, has gone on liquidation, my lord.
Similar employee has been
We have
replied.
nothing to do with it.
Liquidator has been appointed, my lord.
The company has. Any matter?
Similar employee has been replied that no liquidator has been appointed.
But still, now nothing can be done in the contempt proceeding.
Well, direction was to pay the dues, my lord, only 80,000.
No, but the company has gone for liquidation, Mr. Counsel.
My lord, voluntary retirement was introduced by the state government. It is DFID, public enterprise sponsored reform program.
No, you
They
were,
paid all the dues. Company has nothing to pay, my lord.
you were employee of
You lost,
OSTC Limited.
my lord, pardon, my lord, your lordship may peruse the OP number 3, the management corporation, filed affidavit by flag number D, my lord. Running page, inside file, flag number D file. Running page 17, annexure VY3, at serial number 14, my name appears. Your lordship may see, Bhaskar Sahni, WBC number at my dues admitted 72,502 plus, that is arrear, and 8,496, that is provident fund. And in the next paragraph, page 18, I therefore request you an amount of total 32 workmen, 22,47,690. They have returned to the government and arrear dues 3,43,030. They have approved the state government to sanction so that they can pay my lord. This is the stalemate, my lord. Government is sitting over the my file in spite of direction that the OP1 is to pay, my lord. That is the question.
Who is OP1?
State government, public enterprise department, my lord.
How OP1 can pay?
My lord, that is the direction.
Yes, yes.
Because the voluntary retirement scheme was sponsored by the state government, not by the management himself, my lord. So the entire fund was paid by the state government, not by the company, my lord. So the dues are to be paid by the government.
Let us see the order first. Where is the order of this court?
Order I have put it in the writ petition, my lord.
Contempt petition.
Yes, sir. Paragraph, page number 5, my lord. Paragraph 3. In the aforesaid scenario, this court feels that ends of justice and equity will be better served if opposite party number 1 is directed to comply with the direction issued by this court in the earlier writ petition as expeditiously as possible, preferably within a period of 6 months from the date of communication of this order, if there will be no impediment. My lord.
Who is opposite party number 1?
Opposite party number was
Who is opposite party number 1?
Principal Secretary, Public Enterprise Department, State Government of Odisha. Of Principal Secretary, Public Enterprises Department.
I think that Patnaik has retired. He is no more there.
Now, Pradeep Jana is Mr. Nasser, other that name can be removed. So new name can be inserted.
I'll take instruction, let him serve a copy, so I'll take instruction.
Copy already.
Give me another copy, I don't have a copy.
We'll see.
My,
As jointly requested, we will have a look at it. But yes.
Item number 6.
Okay.
Friday, it will come on Friday. Yes.
My lord, on behalf of Mr. Vijay, matter has become infectious.
Infectious.
And letter name is taken to record, my lord.
All right, we'll.
Item number 7.
There is no recommendation on behalf of this happened from the application of the press.
So, item 7 to 35. It is covered by lordship's order.
$33 is something different. 33 is different, that can university.
7 to 35 or only 7?
There's 33 hours, sir.
Yes, my lord, 33 is not there. 33 is something different case. 33 is something different.
नहीं sir. Whole list अपन जो 33 का अनुग वर्ग से अपन करते हैं तो
3 lists were confused.
Man,
I'm sorry. I'm sorry. I'm sorry, ma'am. Which number of lists by
38, 41, 42.
up to 33, then 38, 41, out to
35, 34.
7 to 35.
35. Then my lord, 38, 41, 42. Item number 7 to 35. Item number 36.
36, no instruction. No instruction.
No,
I mean, my presentation, I'm applying for the content. My presentation.
studio office.
Dispose of matter. More advanced cases.
3644 of 2010. And
Item 37.
on appears to business application.
Item number 38. No, 38, 38, 41, 42 is covered by that.
38, 39.
Item 39.
Non appears to business application.
Item 40. Item 43. Item number 44.
No instruction. Take orderly assignment.
Item 45.
My lord, kindly withdraw the.
Yeah, give your memo.
Yes, my lord. 45, 46 and 47. 47.
Item 45, 46 and 47.
47.
Can you give your memo?
Yes, no. I will give you.
Item 48.
My lord, I may kindly excuse the item number 37, the petitioner is dead, it needs substitution.
7 is the question of substitution.
Petitioner is dead, died in that.
No, but whether the cause of action is there. When did he die? When did he die?
He died 2 to 3 months back.
Whether cause of,
Just last night I took from the matter.
is there something in the order which is to be complied with?
Yes, my lord, yes, my lord.
There is something. Right.
Item 48. Item number 48.
No appeals.
ଏଇଠି ଆରମ୍ଭ ହେଲାଣି ତମର ଏଇଟା ଏଠି
Yes.
Item 49.
Yes.
Order not complied, man.
Compared with.
Item 50.
My lord,
Item 51.
Item number 51 Lordship, last night I took into instruction. Petition number 3 and 4 have died in the meanwhile. Petition number 3 and 4.
What is the order?
This order has not been complied. This is regarding payment of dues, has not been complied.
Friday.
Office shows that no copy has been served on office.
I'll serve a copy. This is against the Cooperative Development Bank. So it's a separate
State is not a party.
separate panel of
They have
concerns.
to send notice.
Next Friday.
Item number 52.
No, yes.
Item 53. No instruction, my lord. Item 54.
Yes.
Item number 55.
Item 55, my lord, on behalf of the petitioner, I am appearing through VC. I pay for 1 week time to take instruction in the matter.
Why it is 2012 matter, must have been complied with. And since you have not received any instruction, that means that the petitioner has no interest.
No, my lord, he is a tribal lady, old lady.
All
No,
right.
I-
Friday.
Item 56.
Lordship, item 56, the order has been complied with. It has become infructuous, Lordship.
Item 57.
My lord, page 16, may kindly be saying, of the order passed by this honorable court, paragraph 7.
Just a minute.
In view of the above facts and circumstances, we dispose of the writ application petition with the direction that the steps should be taken by the university authorities and as well as by the state government to regularize the services of the petitioners on expeditiously as possible. It is needless to say that if necessary recommendation is made by the university authority, then that I think the same shall be considered with a pragmatic view following the state center, my lord. Till today, we have not been regularized.
Till today,
My lord,
till today they have
no,
no
we have not been regularized.
regular, there was no direction to regularize.
My lord,
The direction was.
following the ratio of the judgment of Honorable Supreme Court in the case of vulnerability, etc., and necessary orders shall be passed in accordance with the law. No orders have been passed till today, my lord. A counter was filed when they have said that they have referred the matter to the state government. The state government has not taken any decision, as a result of which my lords we have been continuing without being regularized.
Yes, seek instruction.
Yes, sir. The university counter is there, but
State has not
they
taken
have
any
not filed any counter.
Justice. Friday.
Item 58.
On appeals.
Item 59.
Come on.
Item number 60.
Come on.
Item 61.
May I play item 58? Item 48.
48. Where were you when the matter was filed? What do you want 48?
But it is for compliance of the order, there is a direction to issue revised mark sheet. There is a discrepancy by the examining system. So after intervention of this honorable court, there is an enhancement of 14 marks. They have to issue the revised mark sheet showing the previous date of publication that they have not done. This court specifically directed, now they are not compliant.
They
That
are
is
not
for this
compliant.
purpose that is to be calculated. Date of
48.
48.
Item 48.
And read appeal also,
Non-appeal.
read appeal also they lost. This court
You are from the other side.
I am
Which university is this? Which board is this? Which board?
This 48 item.
Who had to issue mark sheet?
The control of examination, CHS.
Control examination?
Control of examination, CHS.
Council of Higher Secondary Education, there is a separate panel.
Sambalpur University, yes.
We'll take up the matter on next Friday. In the meanwhile, you please tell who appears on behalf of the council. Who appears?
CHS seniors.
No, that's
Council of Higher Secondary.
Yes, I'm there in the panel, but triple
Mr. Purohit has already appeared.
somebody appeared in your.
Purohit has already.
Yes, already appeared. He was also there.
There is no request taken on behalf of the contenders. Oh, this case on Friday.
On behalf of Shishir Kumar Purohit. On behalf of Shishir Kumar Purohit, my lord.
Seek instruction.
I don't know instruction.
Yes. Okay. Meanwhile, the council representing the contenders shall be required to inform this court about the compliance of this court's order, violation of which has been raised in the application. It is made clear that if the order has not so far been complied with, the same must be complied with by the next Friday, in which the court will have no other option but to take a strict view of the matter.
Item number 61. In this case, they have filed a show cause stating therein that they have challenged the order of the Honorable Single Judge before this division bench in a writ appeal number 479/2015. As per my instruction, the writ appeal was dismissed by law. But still they have not.
Are you sure that the order has not been complied with?
Today morning, I have contacted my client, but due to you will also can be taken up next Friday. In the meantime,
All right.
item 62.
On appeal.
Item number 63. That this content application arises for non-compliance of the order passed by this Honorable Court, Your Lordship. In that order, this Honorable Court specifically directed to mutate the suit line in favor of the petitioner, Your Lordship. And the petitioner filed a suit before the civil judge, and the civil judge declared the suit, declared the right title interest.
No, but there is a review pending.
Your Lordship, that review is pending, but no specific order is there. And after filing of this contempt application, we got to know that the review application has been filed just because the opposite parties filed the objects.
The petitioner in the present contempt application alleged disobedience of an order of this court dated, what is the date? What is the date of the order?
Well, the date of the order is 22/11/2012.
22. What is the order? What is the date of the order?
In WPC number 15602. 15, sorry.
Just a minute.
Yes, sir. 21/02/2013.
24/7/2013. Passed in WP C number 15602 of 2013. From records, I find that there is a review application seeking review of the said order by the RV WPET 114 of 2014. Stop. Next. The said, who is for the petitioner in review petition?
Yes, I am for the content.
You are for the, and who
Review
is?
petitioner.
Huh?
Review application has been filed by the.
You are for the review petitioner.
Yes, madam.
So I'll hear you on Friday.
Next Friday, that review application.
Yes, review application. Do you have the notice of review application?
No, Your Lordship, it has been filed since 2014, but 2 years, 10 years have passed, no notice has been received, my lord.
Take it, receive it. Counsel for the petitioner appearing in the contempt petition accepts notice of the notice of RVPET 114 of 2014. So list both the matters on next Friday. Next Friday.
Oblige, Your Lordship. 64. 64, Your Lordship, the file is not traceable.
Not pressed. Not pressed.
If the cause of action survives, I will file
That is
item 65, oblige, Your Lordship.
one appears.
Item number 66.
Kindly pass over, my senior will come.
Why, madam?
Yes, madam.
Why pass over?
My senior will come, my lord. It's too late.
Friday.
Item 67. 67. Item 68. Item 68.
No pressed.
Item 69.
Pressed.
Item 70.
My lord, item number 70, we have no instructions.
No instruction, no pressed.
Item 71.
No one appears. My lord. No one appears on behalf of the petitioner to press his application. This application stands disposed of for default. Dismiss for default. Yes. 70.
Melody in the 72, I 72. 72. So in this case, I
70 लिखा है 70 is no answer. 72 has become.
so instead of
72 it is called also.
72 times I contacted to the plant miller and he stated that the case has not been considered by the OEAP. Will come next 5 minutes so that I will give all sorts of documents and
Which item?
72.
All right.
Next week.
Friday, next Friday, well, as requested.
Item 73. For opposite party member, petitioner committee.
On appears. There's this contempt application.
Item 74.
Item 74 matter became infructuous.
Yes,
Item 75.
on appears.
Item number 76.
Item 76, my lord, we could not establish any contact with the petitioner.
No instructions.
Item 77.
Instruction.
77.
On appears.
Item 78. My please, Your Lordship. I filed a bail application, Your Lordship, 135 Electricity Act, and interim protection was granted to me. And matter was directed to be posted on a last week of March 2014. It was not listed. Till then, it will operate. On 19/4/2014, I was arrested. I showed that order, my lord, to the earlier to that, I had given a Xerox copy to the officer concerned. I showed the Xerox original copy. In spite of that, I was forwarded to court. That is why I am before Your Lordship, the overreaching Your Lordship's order. And on the same day, I was released by the equivalent court below, incorporating therein that I had produced the original certified copy before him.
After.
This order. I am, as such, I am a woman, my lord. It's not a question. So,
78.
a lady's right, Your Lordship, otherwise. Otherwise, the lady's right also. He should have taken care of a police officer, my lord.
No. What now? The
There is a so-called affidavit here. So-called the inquiry also is in my favor. That says that he should have been careful.
that we will also.
DCP inquired into the matter. Yes,
Charge sheet has been submitted. Matter is closed.
The petitioner has alleged disobedience of an order of this court dated 19/2/2014, passed in BL-APL number 240 of 2000.
240 possible, my lord.
240.
240.
240 of 2014, whereby interim protection from arrest was granted.
Yes, Your Lordship.
Stop. It appears that interim protection was till
Till end of March. No, that is not like that, my lord. Subject to conduct, put up this matter in the 4th week of March 2014. As an interim measure, the petitioner shall not be arrested. That is at page 2, my lord, in connection with special energy case number till the next date. Till the next date.
when was he or she arrested?
I was arrested on 19/4. That is not the ground that it had expired. Ground was that I did not produce the certified copy before him.
That is the point. Whereby the petitioner's arrest was stayed in the next date. Stop. The said BLAPL was directed to be listed in the 4th week of March. Stop. The petitioner was arrested, however, on 19/4/2014. And senior counsel appearing on behalf of the petitioner has submitted that despite the fact that the interim order passed by, that the said interim order passed by the court was shown by the petitioner to the police, she was arrested in flagrant violation of this court's order. Stop. Next. So-called reply has been filed on behalf of,
IIC Energy PS.
huh?
IIC Energy PS.
On behalf of the in charge.
Inspector in charge,
Inspector
Energy Police Station.
Energy Police Station. Stop.
Para 9 and 10.
Next.
In this connection, may I submit a little further? If your lordship would look at that order which I is showing, my lord, interim order, page 2. As an interim, the petitioner shall not be arrested in connection with such and such till the next date, subject to condition. The learned counsel for the state is directed to cause production of the case diary along with the criminal antecedents of the petitioner. So question now arises, or I feel, my lord, I should espouse. The state counsel must have asked for instruction, while seeking instruction, he must have given that interim order has been passed.
See, despite the order having been shown, you could have been arrested.
My lord,
Because despite that order, you could have been arrested on 19/4,
no, I could not have been.
right?
The expiry date is not there, your lordship, in the order.
It is saying next day.
Till the next
And
date,
it was in March.
it was not listed.
So you could have said that the time is going to expire.
No, no, your lordship are saying time and again, your lordship, in this court, if it is not listed, not listed, not listed.
Even
It is deemed to be extended, my lord. And that is not the ground. He says that it was never made available to me.
sir, we are dealing with a contempt matter. Station. Stop. No, but he's a different constable.
My lord.
Says it's shown by constable.
No, no, no. I, Rajendra Kumar Mandal,
Paragraph 11.
at present working as inspector in charge,
Paragraph 11.
11 of the affidavit, or referring
11 of the so-called.
There are two so causes. That is implied to para 10, it is on
The paragraph 11 of so-called. That is only so-called. Paragraph 11.
the main so cause is filed by the inspector in charge.
All right, but there is one so-called filed by the constable had arrested you.
Oh, that is another so. Rajkishore Mandal. Durgesh Chandra Nayak, the constable. That is
No, no,
second
there
so
is-
cause.
There is a second so-called that has been shown by the deponent. He had arrested you, the police constable.
They took me by a PCR van to the police station from my office, from my house. Then there, your lordship, they arrested me and produced me before the court. Now the court's order, if your lordship, I know I'm not on duty, my lord. Whatever lord passes the order, but I have, it is my duty to bring to your kind notice, your lordship. Court says on the same day it was produced, and the court says it is not a fact that I was brought home and collected some paper. It was not like that. Hard learned counsel for the accused in learned additional PP. The lady accused is forwarded for the offence under 135 of the Electricity Act with the allegation of such and such. Learned counsel for this accused filed certified copy of the order of the Honorable Court in BL appeal number 240 of 2014, dated 19 to 2014, wherein the Honorable Court observed that as an interim measure, the petitioner shall not be arrested. The petitioner is a widow, age about 50, and permanent resident such and such, taking into consideration the fact record, the Honorable Court petition is allowed. So what my humble submission would be, if it could be produced by her before the court, is it imaginable, my lord, that he won't produce it before the police station, in the police station? This is the respect the police has got for the Honorable Court's order. That is why I am here, my lord.
And the police constable who had arrested the petitioner. Stop. Next, the fact remains that when the petitioner was produced before the court, he was released on bail. She was immediately released on the next day, 24. You were released on the next day
On the same day,
on
19/4.
Same,
19/4,
same day.
2014 till stop. Next, in view of the petty nature of the matter, I am not inclined to entertain. I am not inclined to proceed in the present matter, which is of 2014. Stop. The application stands disposed of accordingly. Yes.
Item number 79.
I beg to pardon, my lord. That way, item 30, my lord, I beg to pardon, item 30, my lord. Just, it has been also considered, my lords, for dismissed.
Let the list be adjusted, then any other matter can be mentioned. The list adjust is.
Let us.
No problem.
Item 79.
Yes, no one appears.
Item 80.
Infructuous.
Infectious.
Item 81. 84 to matter. 82 matters.
81, not placed, my lordship, not placed, not placed. Published.
Item 82.
No one appears.
Item number 83.
The order of the Supreme Court has been already been complied with, published.
Item 84.
No one appears.
85.
Complied with.
Item 86.
I am appearing for the opposite party.
The petitioner तो नहीं होगा.
Order complied with.
So, my lord, actually, I have left the service in 2017. I am no longer in that course, continuing in that course.
You are not representing now.
I am no longer.
He is appearing for the contender. He is saying that he has already left that court. So the petitioner is not before your lordship.
No one appears on behalf of the petitioner. Yes.
87.
Yes. No one appears.
Item 88.
Let's see, 88, the brief has been transferred now. The brief has been transferred now. So, madam, you are not appearing? No, madam. All right, no one appears.
Item 89.
You know, as against the counter, I have filed the agenda, and against that, they have filed the additional counter affidavit at Part C. That copy I have not been solved. And wrongly, perhaps it is noted that the case is read petition is disposed of, but the read petition is pending. I just seek a copy of the additional affidavit at Part C, because now it is a question that the direct violation by the container, there are several containers, only one container is filed. And against that container, the collector himself has also given a finding that the Tahsildar has committed the violation of the course of the order of the honorable court, not only of this honorable court, but also of the decree. So there are several contentions are there, and to that he said that he has no knowledge. To that extent, I have given the copy of the CD to show how direct he towards against the. I have also given the entire narration that he said that I don't know what is happening. And all these things are.
Where is the order? Where is the order?
I just may direct a copy to be solved additional affidavit.
Where is the order that is?
At page 4, I have quoted that. Order number 3, 19/1/15, miscase number 539 of 15, in the interim it is directed that no coercive action shall be taken against the petitioners pursuant to the annexure 17 till the next date. Evasion series is that the notice under the Appeal Act and the contention in the writ petition is that the Tahsildar has no jurisdiction with regard to the Appeal Act, exercise of power in the Appeal Act, because it is the land itself is recorded as a hatta governed under the Gram Panchayat. So it is without jurisdiction. That is why the writ petition is there. And despite we show the certified copy, it is also come in the record at page 10 that knowing everything, all in presence of all officers, it was shown, and how coercive action is taken. That is also the CD is there that I have given.
No, where is the, why is the main matter pending since 2015?
For that I have no, because if the original case is taken up, the writ petition is taken up, it will be highly solicited because let that be disposal. But at that direction is given to the by the Sonal Court and the threshold of the High Court,
Mr. Counsel, there was an interim order passed in the writ petition. That writ petition, there was an interim order passed in the writ petition.
Yes, my lord.
That writ petition is pending.
Yes, my lord.
Did you?
That one of the cases is
Okay.
What can be done in a contempt proceeding?
my lord, in the another case,
What is the scope of contempt proceeding?
scope of against the violation, not only the civil but also the criminal violation that is there. And in the meantime, another writ petition has been disposed of.
Consent application arrived also. An order dated 19/1/2015, passed in WPC number 500 of 2015, which is still pending. So stop. List WPC number 500 2015 before appropriate. Before the assigned bench. On 4 weeks ka time. Yes.
My lord, also may kind of
The
with regard to the contempt, let it be heard along with the writ petition or my lord, I could not hear it.
the present contempt application shall be taken up after disposal of WPC number so and so.
Because it is another case, my lord has directed it directed the concerned authority to restore the possession of the petitioner.
In contempt matter,
Yes,
in contempt matter restoration, my lord, your lordship may hear the main writ petition. This is arising out of an intent. Your lordship may shift to next 90.
Item 90.
one more prayer I may make if my lord will allow me. There are several contemners. Only one contemner has filed in the meantime, before hearing. Let others also file the.
See, we cannot compel them to file. If they don't file, if they decide to be punished, then they will be punished. In the absence of any so-called reply.
Normally in these.
We can give them liberty to file so-called. They will have that opportunity. We can give them opportunity to file so-called. If they don't file, they will suffer.
May also observe that.
Not required.
Item number 90.
90 and 91, I put in next week.
Why?
No instruction has been obtained
Then no instruction, all right, 1991.
Next week.
next week.
Item 92.
Yes, is there something surviving? None appears.
Item 93.
In 93, there was a direction by the Honorable Court to comply the order within 3 months. But the customer has not complied that order. And
Where is that order?
Sorry?
Where is that order?
That is order I have quoted. On page 2, contempt petition 276, page 2, that is para 2 last. I'll run a counsel for the petitioner and run a counsel for appearing for the Bhubaneswar Developmental Authority. This petition has been filed challenging the inaction of the BDA is not implementing the order dated 31/5/2001 passed in UP case number 196/1 under 91 of the BDA Act. Our counsel for the Bhubaneswar Development Authority submits that order of the authority that TSA passed in UP the case number will be complied. Implemented within 3 months.
What is the order?
Order was passed to implement the order of the BDA.
Wait.
My lord, that has not been done.
So that there is some explanation.
No?
There is some explanation why.
That they have taken some portion of the demolished and when gone up for second time, there is education and it is.
Yes.
For which they could not be done it.
Yeah.
What happened in this case?
Only one intervention.
So at least they did not have any intention to violate the court's order.
No, but they have not complied the court's order in 3 months. That is the fact.
How matter would have been different? How the matter would have been different? He will have to show the intention of the contemner that they willfully violated the court order.
That they are not taking action in proper time.
All right.
That is one. The second item in this case, you have a writ application. Which writ application has been filed.
Writ application is pending.
It is this item.
Applications will be taken up.
Actually, what are
Writ applications are not taken up with the contempt petitions. The contempt petitions are to be taken up with the writ petition.
So, they will directed to contempt order at least.
Don't know, the writ petition is pending.
The petition there is an interim order of status quo.
And in the writ petition, there is an interim order.
Yes, madam.
So why should we proceed with the contempt case?
So,
Why? Contempt we are dropping, writ petitions will be taken up. Petition, yes, that can be done. Not for the contempt petition. In the present contempt application, the petitioner alleges disobedience of this court's order dated 34/2014, passed in WPC number 2806 of 2013, whereby this court had directed the contemners to comply the order passed in what is UAP case number 196 of 2001 under section 91(1) of the Orissa Development Act within 3 months. Stop. A so-called reply has been filed on behalf of the contemners wherein it has been stated that in terms of the said order of this court, the demolition was required to be orders of this court, the demolition of unauthorized structure was required to be effected and accordingly a date was fixed on 8/12/2015. Stop. On 8/12/2015, part of the construction was demolished. Stop. Subsequently, however, because of law and order situation, and since few lady members of the slum families raised protests and attempted to commit self-immolation, the order passed in UAP case number 196 of 2001 could not be fully complied with. Stop. After having complied with further, one of the affected parties approached this court by filing a writ petition 8251 of 2016 against the action of the Bhubaneswar Development Authority. We can understand. We understand that affected persons was not made a party. No. 16. Against the action of the BDA under the order passed in UAP case number 196 of 2001. Stop. This. In the said case, an interim order of status quo has been passed. Stop. Next, learned counsel appearing on behalf of the petitioner has submitted that the contemners ought to have complied with the order within 3 months as directed by this court. Stop. Since they did not comply with this order within 3 months, this court should initiate contempt proceeding against them. So next, I have heard learned counsel for the petitioner and learned counsel for the contemners. I have perused the so-called notice, so-called reply filed by the contemner. Stop. On careful perusal of the statements made in the so-called reply, I am satisfied that no willful disobedience of this court's order is made out. Stop. An attempt was made. Apparently, attempts were made to comply with the order, but in the given circumstances and an order of status quo passed by this court, the same could not be fully complied with. Stop. In my view, accordingly, no case of willful disobedience is made out. This contempt proceeding is accordingly dropped. Stop. Let WPC number that is also listed with this. WPC number placed by 15. Let WPC number be placed before the assigned bench 4 weeks. Yes.
Item 94.
Status quo will continue.
Status quo is there. The order of status quo shall continue.
Item 94.
Nothing is there. Soap was not received. Soap was not received. Nothing is there.
No, no, but what is the order?
102. My senior is out of station, file is not there. My senior is out of station, file is not there. Is the number? Next, I play for next week.
Are you scared of the court? Do you have any fear?
No, no.
So please speak loudly.
My senior is
Have that confidence.
Sorry.
And if you can't have that confidence before this court, then it is very difficult to have that confidence before any other court. Please speak loudly.
My senior is out of station,
Yes.
file is not there.
All right. Next
I
item,
play for next week.
as requested.
Item 95.
Please.
No.
Item 96.
Item 96, postal requisites have not been filed. I'll file it in course of that.
What?
This is postal requisites have not been filed, as they're noting. I'll file it in course of the day.
No, but what is this about? Whether the order has been.
Against an interim order, I have filed this contempt application. Because I have plans at page 6 of the contempt application.
All right. Let the petition be taken up. List WPC number 2720 of 2015 before the assigned bench. 4 weeks. Stop. The single judge. The contempt application, CONTC number 386 of 2015 shall also be taken up by the same bench, which takes up the said WPC number 2720 of 2015.
Can a date be fixed, man? Can a date be fixed? Any date?
4 weeks means 4 weeks. 4 weeks can calculate this Friday, next Friday. Yes.
Item 97.
97 lordships, the matter has been complied with, nothing further remains to be achieved.
Complied with. So the contemporary also.
Item 98.
None appears.
Item 99.
Item 99, my lords, no instruction on behalf of my learned senior.
Instruction not pressed.
Grateful. Item 100.
Your lordship can have a look to page 26 of the brief. The order passed, operating portion of the order passed by the Honorable Court. 8 lines from the top. Consequently, the petitioner's date of retirement also treated as 31st March 2014 for all purposes thereby. She may be granted all service benefit treating her to have been retired from service on 31st March 2014. But under the circumstances that the petitioner had not worked for the period from 2011 to 2014, though prevented for no fault of her, she may be paid 50% of back wages for this period, except for the purpose of pension and retirement benefits, which may be released considering her date of birth as 29/3/1954 and the date of retirement of superannuation on 31st March 2014. Thereafter, the notice was issued, my lord, in the content petition. My lord, such workers has been filed. Your lordship can have it. That was on file on 26th of June 2017. A stand was taken in paragraph 6 of the show cause that in reply to the governments made, etc., my lords, the Food Corporation of India has filed an appeal. The writ appeal number 222 of 2015 was filed on time of the Honorable Court has been pleased to issue notice to the President. I will look to the IA file, IA number 43 of 2013. This Honorable Court has dismissed the writ appeal and the interim order has been vacated. I have annexed that order at best.
Yes, who is for the other side?
My lord?
Who is for the other side?
My lord, so the second this Food Corporation of India.
When was the issue notice? Notice was issued what?
Notice was issued by Because issued, he has filed the show cause.
There is no representation on behalf of the contemners. Stop this matter on Friday. Can you ask your junior to inform him?
I will inform him. I asked my associate to inform him. The name which appears in the cause list.
Item number 101.
This your lordship, the interim order dated 25/8/2011 has been violated by the state authorities. But that is in contempt proceeding.
Yes,
The contempt proceeding has been initiated for the reason being the
the council, you're right. Some order is violated, the action is required to be taken. But these matters are of 2015. 2015, you are alleging disobedience of an interim order passed by this. And this petition is pending for last 9 years.
Yes, your lordship.
So you are getting nothing.
So
You should have taken steps for the adjudication in the petition.
I will bow down to that.
वो कर दो WPC number 4 weeks sign bench.
The read petition may be listed before the appropriate bench.
Item 102.
Yes. No appears.
Item 103.
No appears.
A caste certificate was needed for a minor girl. The petition was filed by his father, her father.
No, what is the order?
Order was passed by my lord. That was not. The order was, the petitioner has prayed for.
Come to paragraph 4. Is that the order?
Order is
Paragraph 4.
page 27.
Order has been complied.
Last part of the order, considering the innocuous prayer.
Considering the innocuous prayer, just see the observation of the court. Considering the innocuous, your prayer itself was innocuous.
Well, the petitioner was put that was the prayer because everything was inquired into. Even Adivasi, a scheduled tribe.
All right.
She is
It has been complied with, please, Mr. It has been complied with.
his caste
That has been complied with, that is the so cause. That is so cause. We have
After
filed
having
so
heard and counsel for the
is not also complied with properly.
counsel for the
For a caste certificate,
appearing
it's a caste. And the scheduled tribe's caste certificate.
on behalf of the contenders and having perused the so-called reply filed on behalf of so-called affidavit filed on behalf of the contenders, I am satisfied that this court's order dated 1/5/2015 has passed in WPC number 1548 of 2015 has been complied with. Stop. The contempt proceeding stands stopped accordingly. Yes.
Item 104.
On appears.
Item 105.
And the petitioner, the order has been complied.
Complied with.
Item 106.
Non-compliance of the order dated 23/2/2015. The disbursement was directed to consider the representation. So till today that not been considered. The representation has not been considered till today, my lord.
Lawsuit representation not been considered, lawsuit 4 weeks time, lawsuit call thereafter so that we can find it out. Lawsuit has been pleased to grant 5 weeks time yesterday was
so far as representations are concerned, also call the appeal and in time I'll find out whether it has been disposed of or not. Or I will file an appeal to that effect.
No, let it come on next Friday because this is of 2015.
All right.
You might have complied with.
Yes, I will file it.
Friday, I requested on behalf of the contenders.
Item 107.
Well, please. As against the injured on the third day, he was returned. Though the order was passed on 21/8/2015, on the very day, he was returned. That's why I challenged the highly contempt petition, and that is pending where notice has been issued. And
But the contempt petition is contempt has become infructuous.
but on the very day, when the court asked the order, my lord, on the same day, I was returned, my lord. Even though they are in the order, the petitioner shall not be discharged.
So you will have to demonstrate that after they received the court's order, it retrains you.
Normal. The petitioner gave the information to the appropriate parties that the court order has already passed.
You will have to establish that. How can you establish? Information telephonically.
I'm asking for opposite person. We have filed a show cause, my lord. The annexure can be seen. The interim order was passed on 21/8/2015. But the petitioner was removed on 18/8. The order was removal of was passed on 18/8. That would be given effect from 21. Annexure A/2 may kindly be seen, my lord.
Each application was disposed of loss to consider case loss. In the meantime, he was retired from service. We have paid him the benefits. Because now the regular pension is also being granted, and steps are being taken for payment of regular pension loss. So they are the case. It is a case. Content number content number daily order का नहीं देखो भी देता करे
1192 अपन 1192 तो रिटायर की पेंशन करेंगे
We have been appointed by
it will come next week so that the petitioner I will call the petitioner to for this court matter maybe she will come.
All right, I requested on behalf of next Friday.
Item 108.
You also may see the order dated 10/2/2015. And against that order, state order moved the writ of appeal, and the writ of appeal has also been dismissed on 26/9/2022. Till date balance, no compliance has been.
Yes, my lord.
This so cause affidavit has been filed regarding. We'll take instruction. What is the current status?
2 weeks after.
2 weeks.
Item 109.
Is as requested on behalf of the contenders. Let this matter on 2 weeks, so as to enable him to seek instructions as regards compliance of this court's order.
Item 109.
Yes. None appears.
110.
So order dated 25th March 2030 is not compliant. The petitioner is the senior assistant in the urban cooperative bank, and was promoted to officiating assistant manager for the last 15 years. Which means in 1995 to 2010. But
Which order has not been complied with?
order dated 25th March.
Where is that order?
In page 3, it is quoted there.
Yes.
Page 2, para 2.
The concepts of case number.
Understood.
consider the representation. So whether representation has been considered.
Noted. Representation is given, but no reply is being received from the authority.
So there is so-called affidavit available on record.
But we have not received any so-called affidavit.
Bank has filed a so-called.
Bank has filed.
Okay, state or chief?
That president
The bank or chief?
or bank.
When did you talk to your client last?
Yesterday.
Yesterday.
Yeah.
100?
My lord, pardon to say, because of the when we delay replying to that content, we have filed a writ petition. We have come with along with this.
The contempt is not met out because they have taken steps, they have complied with the order.
But we have not received any complaints report.
Who is appearing for the contemptor?
Bank is the.
Can you give him a copy?
So presently I don't know, it's engaged for the bank. Ever since 2014.
For Siddhartha Das.
Does this matter on 2 weeks? So further, there is no representation on behalf of the contenders. Does this matter on 2 weeks? Can you give him a copy? Yes, ma'am. Let me a copy of the so-called affidavit filed on behalf of opposite party number 1 be made available to learn counsel for the petitioner.
Item 111. Disposal of the appeal, during this stay order, disposal of the appeal before the settlement officer quarter, major settlement, quarter matter. That the stay order is granted by the Honorable Court. Mine, the ROR has published in 31st.
So what happened to that writ petition?
Yes, madam.
Writ petition is pending.
Petition is pending.
Writ petition is still pending.
Still pending. But my grievance is there, my lord.
So this will be taken up with that writ petition. The petitioner has alleged in the present contempt application disobedience of an interim order passed in WPC number 1414 of 2014, which is still pending.
I'm for the petitioner. So, I don't have to file your lordship. I'll just assist your lordship regarding the development. In this content, on 21/3/2016, an order was passed, whether the original order passed in the writ petition has been complied with or not. That was challenged in a content appeal. That is content appeal number 2 of 2016. There, the Honorable Division Bench has been pleased to effect the very order passed in the writ petition. So that's this content final will no more be.
It has been rightly submitted by learned senior counsel appearing on behalf of the petitioner that because of subsequent development, the contempt
Not by the government, by the Gram Panchayat.
So subsequent action
Who will be here in this contempt petition?
Subsequent action or development?
Pardon me.
What is subsequent to this?
Now, this order that was passed on 21/3/2016 in this content.
So I am recording that because of subsequent development, this writ application has, this contempt application has become.
Subsequent development.
This contempt application has become. Contempt. This matter stands disposed of accordingly.
113.
Compliant.
Liquids on this case.
MC, this case 369, 2016 stands disposed of.
Item 114.
I am appearing for the opposite party. The order has been complete.
Law appears on behalf of the petitioner and counsel representing the contenders submits that this court's order violation of which has been erased, has since been complied with. Contempt proceeding stands dropped accordingly.
Item number 115.
115, I pray next Friday, I will take instruction and file objection to the complaint. Pursuant to order of this Honorable Court on 19/2/2024, we have filed a compliance affidavit without considering the observation made in the impugned order.
So what was the direction? The direction was to consider.
Direction was a full at page minor 3, I have quoted. In the
The
subsequent
direction is at page 5.
5, that therefore I am reading my letter, just page 5, 3 lines from the top. Therefore, the petitioner submitted representation before the opposite party number 2 to allow him proper scale of pay. In spite of such representation, the benefit has not been granted to the petitioner. Therefore, the petitioner has filed this application, naming his pay scale of 700 to 1600 with effect on so and so, and since the original.
What is the direction? The direction was for consideration of his grievance.
To consider the grievance opposite party.
It had not been considered.
Not been considered properly.
Properly is different.
So, my lord,
Properly you will have to tell.
several adjournments on 19/2/2024, they have pursuant to the order of this Honorable Court on dated 19/2/2024, they have filed an compliance affidavit without considering the observation. So what is
the observation?
The observation is.
The observation was that other documents have been placed before opposite party number 2 for consideration of grievance. Consider the claim of the petitioner and examine the record to produce. Sorry. You can challenge that.
So I pray only next week, next Friday, so that I can highlight.
Not
objection to that.
No. Following was the order passed by this court. Following is the operative person of the order of this court dated 3/12/2014, passed in WPC number 11797 of 2013, violation of which is being alleged in the present contempt application. Page 5, from since the original service book. यहाँ पे since से लेकर compliance affidavit has been filed.
Yes, ma'am. On 4/4/2024.
It is submitted on behalf of the contemners that the said order has been complied with in as much as the petitioner's claim has been considered based on the records and an order has been passed, though belatedly. So stop. Belatedly rejecting the petitioner's grievance. Stop. When counsel for the petitioner submits that the petitioner's grievance has not been considered properly while rejecting his claim. Stop. Since an order has been passed by the contemner, in compliance of this court order, in the court's opinion, no case of willful disobedience of this court's order is made out. Stop. It goes without saying that the petitioner shall have the liberty to question the correctness of the order passed by the concerned authority before appropriate forum in accordance with law.
Considering the limited request of the learned counsel for the petitioner, this petition is disposed of with a direction to the member secretary, Orissa State Agricultural Marketing Board. In the event request by letter under Annex 4 under letter number 144 dated 12/6/2012 is still pending consideration, the same may be considered and disposed of within a period of 4 weeks from date of communication of the order. Since the matter is disposed of at the stage of admission, petitioners are directed to serve a copy of the same along with a copy of the writ petition on the opposite part number 2 within a week hence. Then, my lord, we have communicated the order under Annex 2, my lord. But till then, my lord, they have not complied the order under Annex 1.
No, this marketing federation notice has to be issued. The contemner notice, your lordship may issue notice to.
Contemner is the Orissa State Agricultural Marketing Board, my lord. Notice has to board.
This matter is coming up after 8 years.
Ma'am.
The order was passed in 2015.
Yes, ma'am.
And that order is also to consider and dispose of.
Yes, my lord, but they have not yet complied with the same.
And how do you say that this was received by them?
My lord, page 12, my lord. Page 12, my lord, I have enclosed the receipt, my lord, the postal receipt.
What is postal receipt?
Page 12, my lord, I have
so whether that has been received or not?
My lord, as per the instruction, my lord, that has been received, but I will, my lord, place this matter to next week. I will produce some documents whether it has been received on the.
Inquire whether the order has there. Absolutely nothing in the order. Certainly contempt petition for last 8 years.
117.
My lord, 117, my lord, I am appealing for on behalf of Mr. Revijana for opposite party. My lord, already complied, man.
Complied with.
118. May approach. Order dated 8/9/2015, not yet been complied with the contempt number.
What is the order?
Direction was given, my lord, to make correction of the ROR and the appeal party received the same order. And
Where is the order?
My lord,
Where is the order?
at page 8 of the content petition, my lord.
Page 8.
8, my lord. In view of the fact that by order dated 25/6/2014, appeal party 1 had directed the appeal party 2 to make necessary correction of ROR and the appeal party 2 received the said order. The petition application disposed of with the direction of appeal party 2 to comply the aforesaid order within a period of 3 months from the date of production of said protocol of the order.
Yes.
Yes, Lordship may see the so cause affidavit filed. Paragraph 5.
Yes.
It is pertinent to mention here that deponent after the order dated 25th June 2014 passed in lease case number so and so by the Additional Commissioner Settlement Council of Sambalpur initiated mutation case bearing number 175 of 2014 on 18/9/2014 and directed the Amin Subdega Tahsil to conduct field verification. Accordingly, the Amin conducted the field verification and submitted his report wherein it has been mentioned that the suit land lying fallow without any cultivation or possession of any loading. Copy of the report is annexed. Further, one clarification was sought for from the district office for settlement of government land with Kisam Jungle, filed letter number so and so, has issued necessary clarification this regard. Filed letter number so and so, along with the order passed by the collector Sundaro in the note sheet, page note 4, wherein it has been observed that government land with Kisam forest cannot be settled in favor of the petitioner without grant of permission from the concerned divisional forest officer. Legal opinion of the government leader Sundargarh, copy of the letter number so and so is annexed.
So this happened because the writ petition was disposed of on the same day when
Yes,
it was taken
yes.
up. No opportunity to file affidavit.
This is a jungle Kisam land.
The petitioner and the successor of the lessee, my lord. Lease was granted in the year 1964,
Maybe.
my lord.
But this order, what is the meaning of the order which was passed on the very first day?
But the petitioner filed a revision petition before the Commission of Settlement and Commission of Tribunal. That is the annexure, my lord. Poor, my lord.
The petitioner in the present
At page 22, my lord.
That
The commissioner directed to Tahsildar to make necessary correction, my lord.
Sorry. The present contempt application has been filed alleging disobedience of this court's order dated 8/9/2015, passed in WPC number 8257 of 2015. Stop. It is apparent that the said order was passed by this court on the very first day when the matter was taken up without any opportunity to the opposite parties / state of Odisha to file a counter affidavit. Stop. The petitioner following is the relevant portion of the order dated 8/9/2015. Grievance, 2 paragraph, second and third. Stop. So-called reply has been filed on behalf of the opposite parties, stating therein that by the aforesaid order dated 25/6/2014 passed in lease case number 1459 of 1974. क्या लिखे? That after the order dated 25/6/2014 was passed in lease case number 1459 of 1974 by the additional commissioner, settlement and consolidation, Sambalpur, additional commissioner, settlement and consolidation, what is this paragraph 5?
Paragraph 5 here, the deponent has explained.
No, I mean, there's some defect. Sentence of order. It has been stated that the additional commissioner settlement and consolidation Sambalpur had initiated mutation case bearing 175/2014 on 18/9/2014. After the order was passed, order dated 25/6/2000 was passed in lease case number 1459 of 1974 and had directed the Amin of Subidega Tahsil to conduct field verification. So accordingly, the Amin had conducted the field verification and submitted his report, wherein it was mentioned that the suit land lying fallow without any cultivation or possession of any body.
That I have denied in my reply, my lord. That I have denied, my lord. Without any making field verification.
So this fact, did you?
Yes, I have answered, my lord. I have given reply, my lord.
So you are answering in contempt petition. They did not have any opportunity to counter your arguments made in the writ petition.
But after hearing them, the commissioner had directed to make necessary corrections.
Counsel in the petition they have not heard.
But in the writ petition, simply direction was given.
Simple direction will not do. Simple direction, the first day without giving any opportunity, how such orders can be passed? क्या लिखा? Also, it has further been stated that a clarification was sought from the district office for settlement of government land with Kisam Jungle wide data number 3587 dated 17/12/2014. Stop. Accordingly, the district office issued necessary clarification in this regard on 21/2/2015, along with an order passed by the collector Sundargarh in the note sheet, wherein it was observed that the government land with Kisam forest could not be settled in favor of the petitioner without grant of permission from the concerned divisional forest officer. So stop. Next. Paragraph 6. Paragraphs 6 and 7 of the said so-called affidavit are also relevant, which are being reproduced here in below. So stop. Next, learned counsel appearing on behalf of the petitioner has filed a reply to the said so-called affidavit denying the averments made in the denying the factual aspect of the matter as asserted in the so-called reply. So stop. Next, I am not inclined to entertain this contempt application, wherein there is allegation of disobedience of an order passed on the very first day in a writ petition without in a writ petition. No, stop. In my considered opinion, no case of willful disobedience of this court's order is made out in view of the stand taken on behalf of the opposite parties in their so-called reply. The contempt pleading stands stopped accordingly. So it goes without saying that the petitioner shall have liberty to ventilate his grievance before appropriate forum in accordance with law.
Under 19.
For settlement, that was for settlement.
Settlement.
For settlement of land.
Okay.
Yes,
119.
Already compliant.
complied.
120.
Infraction. It is not died.
121.
No one appears.
122.
No appears.
123.
No one appears.
124.
No one appears.
125.
25.
126.
No one appears. Dismiss for default.
127.
127, I am in DC, my lord.
Yes.
Yes, my lord, here, my lord, order dated 2/4/2015, my lord. The relevant portion is at page 9, my lord.
Yes. So,
Considering this,
Mr. Counsel,
yes, my lord.
let the writ petition be taken up first.
Now, on the date the writ petition was disposed of, it was disposed of on 2/4/2015, my lord. And it has been directed that grievance of the petitioner shall be considered taking into account the a circular issued by the government. And this order was communicated, and though it was directed to dispose of the representation within a period of 6 months, 6 weeks, my lord, but it was disposed of after 4 months, my lord. And it has been taken a decision by the authority on 22/8/2015.
So it has been, now your representation has been disposed of. It has been.
No, it has already been directed that taking into account the circular issued by the government, my lord. So the authority has passed that order, and it has been directed that any construction, whatever was made before in the school premises, that should be demolished, my lord. Your lordship may kindly have glance page 15, my lord. So in pursuant that circular, my lord, in view of the circular dated 17/8/2001 of government, the collector and DM Khurda is instructed to ensure that any authorized construction.
Mr. Counsel, where is this court's order?
Internal page, my lord. 3/4, my lord. That in fact the order dated has been wrongly mentioned as 13/8. In fact, that was 2/4/2015, my lord.
All right, your representation has been considered. An order has been passed.
Order has been passed that taking into account the circular issued by the government, my lord.
Sir, whether an order has been passed or not?
The order has been passed after 4 months. During that interregnum period, my lord, the opposite parties have constructed the statute inside the premises of the school, my lord.
All right.
Relevant page is at 15 million.
Sorry, we will not sit. The petitioner has alleged disobedience of this court's order dated 13/8/2012, passed in WPC number. So and so. What is the WPC number?
So
WPC million.
9179 of 2016 gross.
9179 of 2016. Stop. By the said order dated 13/8/2012, comma, considering the grievance of the petitioner, this court disposed of the writ petition with a direction to the Commissioner cum Secretary, Department of School and Mass Education, Orissa, Bhubaneswar, to consider representation as appearing at Annexure 4 series and take a decision in appropriate manner, taking into consideration the circular issued by Government of Odisha School and Education Department, bracketed Annexure 5, within a period of 6 weeks. This is not in dispute that a decision has been that the representation has been considered, whereafter an order has been passed by the Commissioner cum Secretary, Department of and Council, appearing on behalf of Odisha and Council, appearing on behalf of the petitioner, has submitted that the court had directed, the order directed disposal of representation within 6 weeks, but the contender passed the order more than 4 months thereafter, and therefore a case of contempt of this court is made out. Stop. Next. I am not satisfied with the said submission advanced on behalf of the petitioner. Stop. The contenders, in obedience of this court's order, have passed the order. The contender, in obedience of this court's order, has passed the order, though belatedly. Stop. The subsequent conduct of the contender shows that there was no intention to violate this court's order to make out a case of contempt of court. Stop. Next, this contempt proceeding stands stopped accordingly. Yes. 5913. Is the order, Mr. Counsel?
In fact, my lord, that order has been passed on 2/4/2015, my lord. But inadvertently, that has been indicated at 13/8/2012.
5913. Yes.
Item 128.
In fact, here the main petition, I am from the opposite party. The main petition out of which this contempt arises has been disposed of. Therefore, possibly the petitioner is not here.
This is an interim order.
This is against an interim order.
The contempt petition has been filed alleging disobedience of an interim order passed by this court in WPC number.
And that is 8717.
8717 of
2010.
2010. So, Soft and Senior Counsel, appearing on behalf of the petitioner, has submitted that the present contempt application has lost its relevance, the main writ petition having been disposed of
on 30/3/2022.
13/3/2000 on 13/3/2022. The contempt proceeding stands stopped accordingly.
129.
with the effects of time, Land Council for the petitioner has submitted that with the effects of time, this contempt application has become infructuous. This application stands disposed of accordingly.
130,
130, my lord, no instruction.
No instruction.
131,
Not pressed.
And 131 to 136.
Has no instruction to press this application. Hence, dismissed as not pressed.
131 to 136. Just a minute.
Infructuous.
131 to 136.
36.
137,
No one appears.
138.
No one appears.
So we will complete it first.
In the notice, an AGA states that this court's order, violation of which has been alleged in the present application, has been complied with.
139,
No one appears. Press this application. Dismiss for default.
140,
Same order.
141,
Please, under the order dated 22nd of January 2016, you lots will get at page 8 of the contempt petition has not been complied with till date. Well, my lord, the issue involved that the residential house of the petitioner was affected due to natural calamity, the creation of crack.
So what is the order?
Order was, my lord, they filed the counter that proposal has been submitted for due reservation so that it can be recorded in the name of the petitioner. That was in the 2016.
Where is the order, Mr. Counsel?
Page 8, your lordship, have a glance.
Page 8.
Annexure 1 to the content itself.
So whether any decision has been taken on the
No,
proposal?
my lord, that is the till date, my lord, no decision has been taken. My lord, though they said that the proposal was submitted before the ADM and taking into consideration that your lordship directed the collector to take a decision, but till date it has not been.
2016, I filed a count in your so cause saying that your proposal has been submitted for due diligence so that this 12% can be accommodated. Thereafter, no instruction, if you lost it, that.
List this matter on 2 weeks so as to enable learned AGA to seek instructions as regards developments subsequent to filing of the previous so-called affidavit.
Yes. Item 142.
I beg your pardon, my lord, item 140. The compliance report was to be filed, but that has not yet been filed by the content.
Is it?
142. 142 order has been complied with.
Compliant.
Please, 142 complied.
Compliant.
Item 143.
143, no instruction.
No instruction to press this application. Dismiss as not pressed.
144.
144, no instruction.
No instructions.
145.
No one appears.
146.
So if I may please your lordship, my lord. My lord, the order is at annexure 1 and the relevant part is at page 12.
Considering the above scenario of this case, this court, while disposing of the writ petition, directs the district education officer, opposite party number 3, to accord permission to the petitioner to join as PET in DSP High School, Juba, and further directs the
Where
headmaster.
we are reading?
My lord, page 12,
Page 12.
your lordship. My lord has it?
Yes,
May I continue, my lord?
please.
Considering the above scenario of the case, this court, while disposing of the writ petition, directs the district education officer, opposite party number 3, to accord permission to the petitioner to join as PET in DSP High School, Juba, and further directs the headmaster of the school to allow the petitioner to discharge his duty as PET with consequential service benefits forthwith and production of a certified copy of this order. Thereafter, my lord, we have communicated and other things have been done. Thereafter, my lord, show cause affidavits have been filed. My lord, in show cause affidavit, the district education officer, opposite party number 2, has stated that they have sought for permissions from the directorate and have not been able to comply. While order dated 22/4/2019 of this honorable court, lordship, I kindly see that they have taken time, that they need further time to comply, and in that event, further 2 weeks time was granted to them to comply and to file a complaints affidavit. But that till date has not been done. That till date has not been done, your lordship.
So I'll find out yours, also we're calling next week.
Very serious.
Next week, calling yours. Yes.
1 week as requested on behalf of the this matter on 1 week. So it's enable learn AGA to seek instruction as regards compliance of this court's order dated 24/1/2014, passed in WPC number 1014 of 2014.
147, gratefully, lordship.
147, my lord. I say next week on that to take instruction. On that ground, they have filed a compliance affidavit. The initial original order where I have quoted at page 3 to the matter to take a decision on the for regularization. And they have taken a decision on regularization, but not properly. And this, considering the so-called mandate, this honorable court again might order dated 8/7/2019. 8/7/2019, my lord, in the fourth para, my lord, considering the contention laid by the learned counsel for the parties, and after going through the records, it appears that the opposite party filed their so-called reply in
Mr. Counsel, this is not the jurisdiction, this is not within the scope of contempt jurisdiction.
But this honorable again directed that.
My lord, my lord, I'm appearing for the contempt, my lord. The order was made to regularize the employee, my lord, and the employee was regularized since 2004 and ceased drawing the salary as per the scheme, my lord. And we have filed a show cause affidavit and we have explained everything.
Yes.
Now the petitioner is claiming that why he is not getting the salary as per with the cargo handler, my lord. That is not a order, my lord. Where at page 10, my lord, your lordship may kindly see the page 10, my lord.
The petitioner in the present contempt application has alleged disobedience of this court's order dated 18/2/2016, passed in WPC number. Which WPC number?
WPC number 12422 of 2004.
12422 of 2004. So, by the said order dated 18/2/2016, this court had directed the opposite parties in their petition to take a decision as regards petitioner's regularization of service as a female cleaning worker against an existing vacancy. So, in the so-called affidavit filed on behalf of the opposite party number 1, it has been stated that after considering the claim of the petitioner in the light of this court's order, the petitioner's service has been regularized. And she is getting monthly salary from the date of her appointment. So, and counsel for the petitioner has however submitted that the petitioner is not being given salary based on correct scale. Stop. He has stop. There was no direction by this court in the said order dated EP 2016 to grant the petitioner a particular scale of pay or amount of salary. First off, if the petitioner has such grievance in respect of scale or salary or other allowances, she shall be at liberty to approach appropriate forum in accordance with law. No case of deliberate disobedience of this court's order is made out. The contempt proceeding stands stopped accordingly.
At 148.
That's the order dated 15/3/2016 in WPC number 1072 was not there in the court, my lords. It's the order dated 15/3/2016 in WPC number 1072 is under challenge wherein your lordship has disposed of, considering the limited submissions raised at the time of admission, that the representation to be considered within 3 months, my lord. Deliberately, your lordship had issued notice on the contempt. There is a noting that requisites were not sufficient, my lords. Although I have filed the requisites, my lord. And my lords, there's nobody is appearing on behalf of the because of the insufficiency.
What is the order?
That's the order was, because my grievances to be considered by the opposite party number 2 within a period of 3 months.
Where is that?
That is at page 11 minutes.
The problem, Mr. Counsel, is that the order was passed on the very first day when the matter was taken up, writ petition was taken up.
Because the claims were accepted, my lords. The claim of the petitioner were accepted by the opposite party.
Might have been accepted, but they had some right to be heard before any order was passed.
Therefore, I pray, my lords, if your lordship will grant me opportunity and file fresh requisites, let them appear, my lords.
No, in the writ petition.
Let's.
And requisites you did not do.
No, that's I filed. There will be some insufficiency. That is what the noting is.
You're dropping it.
I pray one opportunity.
What?
But I'll file fresh requisites in this case, my lords. One time. Because it was.
No, please come to this order. 15/3/2015.
My lords.
Last but one paragraph.
My lords.
So you did not comply with that.
Lords, I have communicated. That is at page 7, my lords. That is my representation, which was page 7 with the AD receipt. If your lordship will see page 7, that I have communicated to them. Page 7 of. If lordship will see at the bottom, I have annexed the registered post receipt.
is 7 is nothing.
But that is the representation, my lords, as per the order dated.
Is this? Oh, page 7 I cannot, not legible.
Now, that is addressed to the chairman, the managing director of the opposite
You
party.
may read that. The petitioner has alleged disobedience of this court's order dated 15/3/2016, passed in WPC number 1296 of 2016, whereby the chairman cum managing director, Oriental Insurance Company Limited, was asked to where is the order?
Well, the order is at page 11. And page 7 is my.
Was asked to take a decision on the petitioner's representation. So stop. The said order was apparently passed in the absence of the it was not noticed.
No, my lords. It was on the stage of admission itself.
In the past, without issuing notice to the notice bracketed as to the opposite parties in the writ petition. Stop. In my considered view, considering the nature of the order passed by this court and the time elapsed since passing of the order, no case is made out for initiation of contempt proceeding. At this stage, stop. The contempt proceeding stands stop. Stop. The petitioner shall be at liberty to pursue his remedy before appropriate authority. Yes.
It's a 149.
149, no instructions. No instructions.
150.
Compliance report not found. Compliance affidavit not found by the government.
So
the order has passed for like where for getting the secured.
So where is the order?
The secured pay up scale. Secured pay up scale in the school is a teacher.
And where is the order? Where is the order of this court? Which order has been violated? All right, let us.
Yes, mines, even though the matter was taken up in 2019, I have obtained instruction that the sum of rupees was 58,671 was due to be paid to him. Out of 3 lakhs and not 2 lakhs was paid. And it was directed to to disburse the amount on that date, 2019. By now, you must have received, that is my letter showing that the amount should be paid to him by the authority of the Director of Higher Education.
Has been paid. It appears on from the submissions advanced on behalf of the contemners made by an AGA that this court's order violation of which has been alleged in the present application has been complied with, as much as in the year 2019 itself, a sum of rupees 58,000.
Yes, sir.
Remaining sum of rupees
58,000, 671.
671 was directed to be paid. And counsel for the petitioner has no specific instruction as to whether this said amount has been paid or not. So, in any case, it cannot be said that there has been violation of this court's order willfully. So, in such view of the matter, the present contempt application stands, contempt proceeding stands wrong. Yes.
151.
Yeah, my lord, the order under Annexure 3 dated 11/3/2016 at page 12 has been violated by the opposite contender, my lord. The lordship will find page 14 the order, my lord, passed by this honorable court. Second paragraph, the grievance of the petitioner is that though by order dated 17/11/2014 in mutation appeal number 41 of 2013, the sub-collector Kendrapada has set aside the order dated 24/11/2012 passed by the Tahsildar Ali in mutation case number 2498 of 2012. But till yet, the ROR stands in the name of the opposite party number 3. The learned counsel for the petitioner submit that since the order passed by the Tahsildar Ali has been set aside, the consequential order correcting the ROR has no effect. This court finds ample force on the submission of the learned counsel for the petitioner. Since the matter is remitted back to the Tahsildar Ali for de novo inquiry, the ROR shall not be given effect to. But even though this order was given for correcting the ROR, not which has been corrected in the name of the wrongly on the name of the opposite party, till date, my lord, he has not restored.
It is not the question. The question is, since the matter is remitted back to court, Tahsildar for de novo inquiry, the Tahsildar is directed to conclude hearing of the case.
The ROs shall not be given effect to.
Yes.
But that has not been corrected. Which has been corrected by the Tahsildar. And the same was set aside by the sub-collector. And this honorable court has directed to restore the original ROR. That has not been done.
No. The court simply says that is not to be given effect to. That's all.
Yes, my lord.
What is the meaning of not giving effect?
The original ROR, which was in the name of the petitioner, shall not be given effect to. But he has recorded in the name of the.
It was already recorded.
My lord.
That was already recorded. The court says that shall not be given effect to. That will not be given effect to. RO is there, it has ROR is there, but it has no value in view of the court's order. That's all.
But he should.
Where is the direction for correction?
He should have been. He was directed to be conduct and to pass the order.
That is a different thing. Come to that also.
Yes,
there was no direction to pass an order.
No, to conclude the
hearing.
Yes, my lord.
Conclude the hearing. He might have concluded.
He has concluded.
Yes.
But has not corrected the ROR.
Not required. There was no direction. We have to read the order, the language used. There is no direction. The direction is to conclude the hearing. He has concluded the hearing. Now he is free not to pass order.
But the ROR stands in the name of the
It depends on the final order.
My lord, may kindly see his final order, my lord.
Whose final order?
My lord, Tahsildar's, my lord.
But Tahsildar has passed a final order according to the direction of the Supreme Court. So now he can challenge it separately. How can I challenge that in the contempt?
May kindly see.
Mr. Tahsildar has passed an order.
Yes, my lord. So dismissing the mutation case.
Then,
but the order stands in the name of the, my lord. The correction still continues. That is the difficulty, my lord. You actually kindly see the order of the Tahsildar, my lord. At page 37, my lord.
So what for the matter was remitted back to Tahsil?
Tahsildar corrected the ROR that was challenged by the petitioner in the mutation appeal before the sub-collector. Sub-collector said that the order was illegal. The order is set aside and remanded to the Tahsildar for case adjudication. So thereafter, my lord, I filed an application for restoration of the ROR in the name of the original tenant. He did not pass any order. Therefore, I approached this honorable court for directing the Tahsildar to restore the ROR and to conclude the mutation proceeding. He has disposed of the mutation proceeding
in your favor.
In my favor, but did not correct the ROR. Restore the ROR in the name of the original person.
Don't address him.
He has dropped the mutation proceeding on the because of the fact that the civil suit is pending.
Yes.
So that's why we dropped the proceeding. So
you are arguing before him. Are you arguing before him?
No.
Huh? You can do that.
No.
But you can do that outside the court.
No.
So,
the concluding part will also look at the Tahsildar says over the fact that civil suit is pending and there is a direction by the Supreme Court to conclude the mutation proceeding. He has concluded the mutation proceeding, saying that it is dropped subject to Lord's final adjudication of the civil suit. Now it was passed in 2016.
So therefore, the ROR should have
therefore nothing. Therefore depend on suit. Following was the order passed by this court on 11/3/2016 in WPC number 20928 of 2015, violation of which has been alleged in the present contempt application for the entire one. One second. The grievance से लेकर order तक. So, when counsel for the petitioner has submitted that despite the court's order, the ROR has not been corrected in the name of the original tenant. First off, he has next. It is, however, not in dispute that after the matter was remanded back to Tahsildar for de novo inquiry under this court's order, an order has been passed. Where is that?
My lord, page 37.
Concluding part also.
Page 37. Keeping in view the present position of the case, this court do hereby pass an order that the case is dropped till the finalization of the suit in the civil court Ali on CS number 10 of 2016.
It's how the law is that after the merchant was demanded back to the tahsildar for either way under the sports order, command and order has been passed.
You know, inquiry under the court order, under the sports order. An order has been passed by the Tahsildar on 23/7/2016. Dropping the said case till finalization of a civil suit in CS number 10/16 pending in respect of the disputed land. So, next, the court's opinion, no disobedience of this court's order is made out in as much as it cannot be held based on the order passed by the Tahsildar that it was in willful violation of this court's order. So, the contempt proceeding is dropped accordingly. Yes.
152.
Yes, no one appears.
153.
Already complied.
No one appears.
153 already complied petition.
Compliant petition.
154. Informal self-renewal taken up by day, next by day. I'll take some instruction. There is some confusion. I talked with you.
As requested on behalf of the contemners, this matter on next Friday.
Item 155.
Is there any all right? Is there any all right to next week?
My lord, pardon, my lord. First of all, my lord, item 30, that is a contempt, that is a retired employee, my lord.
Item number
40.
Just a minute. Please wait. No.
Special admission item 156.
How many matters are there?
My lord.
298.
Huh?
298.
298. All right. Yes, in all matters up to this.
Item 40.
Item 40, my lord. That is the old matter. That is a retired employee. That is Hindi teacher, my lord. But the GPF dues have not been given in spite of the direction of the Honorable Court. Page 11. That is 9% interest. That is even if the headmaster had also released with such amount and they also deposited it before the controller of account. But that has not been done. In page 10 of the sequence of the order dated 26/3/2004. My lord.
Now, where is the order of this court?
Court order page 10 to 263/2004. Order, my lord, I am permitted to press the order. This improved demands of the petitioner, who is working as a Hindi teacher, is the
Item 40. Just a minute, Mr. Counsel.
My lord.
Which page is the order?
My lord, 26/3/2004, page 10.
Yes.
Of the order in OJC number 17,210/98.
Yes.
That has been in page 10. Reflected on
2004 order has not been
complete till now. Even if he has not get the amount, so that's why it is pending before the Honorable Court, and in repeated time, in my lord, as it is appear in my order sheet, that is in 9 occasions.
You also maintain an order sheet.
Not order sheet, but I have reflected in my before many courts that it is also listed. But state council often directed to take instruction.
This order was passed in 2004.
My lord.
You filed this contempt application in 2010.
No, not a 10. My lord, that is the another page 12, my lord. I have also given in the 2008. My lord, in the another contempt in the 3 to the second contempt, my lord. In the answer 2, page 12, my lord.
Petition was filed in 1998.
98, my lord.
It was disposed of in 2000.
My lord, the disposal of in 2004, my lord.
4.
Thereafter,
And you filed the first contempt petition in 2008.
in the 2005, my lord.
2005.
2005, my lord, page 12, my lord, Canadian laws. Before my lord's page. Then it is also the honorable court free to direct to comply the order. In spite of that order, they have not complied, and then they committed the my lord, I am permitted to non-compliance.
So I'll find out your section 40.
Please find out 4 weeks. Please find out what is the something can be done.
Old matter, password matter, item 66.
66.
The password.
This coming in the next week. Next
It will come next Friday.
Next time. Okay.
Someone was there in item number 140. No, 140.
No.
40. All right. Yes.
First submission item 156.
My lord, just now I received the complaints affidavit, my lord. My lord, I will verify it and let it come next week, my lord.
Let us see the order first.
My lord. My lord, the second part of the order is under annexure 1. Relevant portion is at page
156.
My lord. Relevant portion is page 17, my lord. Hence, the way is allowed, respondent are directed to grant first ACP to the applicants on completion of 15 years of service from the initial date of appointment as untrained MPHW. The respondent are further directed to the grant of second RACP on the completion of 20 years of service from their initial date of appointment, constituting a screening committee. My lord, first part has been already complied, my lord. First part is complied. And the second part has not been complied. Therefore, I filed this contempt petition.
No, this is first one. Hence, both the OAs are allowed. Respondents are directed to grant first ACP.
My lord.
To the applicant on completion of 15 years of service. This has been complied with from the initial date of appointment.
My lord.
The respondents are further directed to grant them second RACP.
My lord.
On completion of 20 years. This has not been complied with.
My lord. Second part has not been complied.
I filed a so-called affidavit, given my copy to my friend. There was stated because he had availed the benefit of your TBA, time-bound advance and scale up after 15 years, he is not entitled to that. Accordingly, the order has been passed. Yes, accordingly, order has been 17/6/2023. This order was passed. It was communicated to him also. I filed the so-called affidavit, given a copy to my
just now I have received, my lord. I will let it come next week.
As requested on behalf of the petitioner, list this matter on Friday.
157. Item 157.
No, not here. What is this? Any instruction?
Implementation laws. There is a direction to consider the implementation laws.
All right, 5 weeks.
Item 158.
Yes, my lord, direction was also issued to the ADM board to consider the representation. Last procedure, my lord, the state asked for time to take instruction.
So implementation laws also when we time do it in the meantime.
4 weeks, 4 weeks.
159.
Kindly have a glance at the last order dated 3/5/2024, my lord. This court, after going through the order dated 27/2016 under annexure P to the compliance affidavit, finds that the said compliance is not in terms of the order passed by the tribunal on 1/12/2015.
Now, where is the order?
Order, my lord. Running page 10, my lord. The diary is page 10, page 10.
Page
To the
10.
contents, my lord. Considering the submissions of both sides, the respondents 1, 2, and 3 are directed to convey review DPC to take up the promotion of the applicant, and for that purpose, they shall procure at least 3 years CCR of the applicant for the period 2009-10 to 2013-14. And as in the meantime,
So this has not been complied with.
yes, they have given promotion. They have given promotion pursuant to the direction of the court, my lord. But the financial benefit has not been given.
Was there any direction?
Yes, my lord. That's last part, my lord. Has been received as a review from the counter. They have to procure CCR to 2 years and convey the review DPC within a period of 4 months from the date of receipt of a copy of this order.
Yes.
And in case
I'll find out more because
2 weeks. As requested on behalf of the contemners.
Item 160.
My lord, this is the third contempt you are seeing. In last occasion.
Third contempt.
Third contempt.
Let us see the first order.
First order, you are also running page 16 of this contempt petition. Running page 16. In this order, this honorable court has directed the contender present opposite by note 3 has directed to dispose of the representation of the present petitioner, that is to disburse the remuneration in pursuance to Annexure 4. Annexure 4 is the work certificates submitted by the present petitioner and given 3 months time to comply this order. Since the opposite party did not consider and remain silent, the first contempt has been filed before this honorable court, that is the order under Annexure
Yes,
3.
Mr.
yes, I find the so-called affidavit. Can you look at on that's dated 8/4/10/4/2024 dated 8/4 minutes. There in my paragraph was 8. I've explained.
Yes.
Paragraph 8 that submitted that the present petitioner is working as the ECG machine operator under Jilla Swasthya Samiti at District Hospital Puri. He was getting his remuneration from Jilla Swasthya Seva Users Fee Collection Fund. But in the year 2018, after introduction of Nidan program by the government of Odisha, the user fee collection has already been stopped. Hence, the opinion of opposite party was no other fund provision to pay the remuneration of the petitioner. In this regard, necessary guidance has already been sought from the government in several times, as mentioned, the written letters to the government, because he is not a regular employee, and he has been paid this remuneration from the user fee. Now the user fee is not being was collected from the persons after 2018 laws. So, this is the so-called was filed, and I'm finding the was so far as these letters under annexure, paragraph 8. What is the response of the government to the letters? I will find out. Also give me some time.
So what was there in Annexure 4?
Annexure 4, your lordship. Of my contempt petition, that is the order of the second contempt. Oh, sorry, first contempt. Annexure 4. 3 months time given. Thereafter, after 3 months, they have did not comply. Thereafter, another second contempt has been filed.
No, what is there in your favor? On what basis this order was passed?
The what certificates have been submitted since the work certificate from the February 2019 to February 2020.
Who had given you the work certificate?
CDMO Kotak, that is Superintendent of Chief District Medical Officer.
You were working there?
Yes, yes, till that I am working.
As what?
As an ECG mechanic.
And even today you are not being paid your salary?
Yes. Till date, I have not been paid my remuneration.
Can you please come to page 30 of this brief? The order passed in the contempt petition. Page 30. 30, paragraph 3. it is submitted by the learned additional government advocate appearing for the opposite party contender that the order passed by the Supreme Court has been complied with. A copy of letter number such and such dated 4/1/23 issued by the CDMO Puri to the petitioner is handed over to the learned counsel petitioner in court today, and a copy of that also filed before this court.
Pressing.
Your Lordship. The letter dated 105 dated 4/1/2023, what my Lord Senior has submitted, can you say annexure 5, Your Lordship?
No, Mr. Please.
That letter.
This contempt 1810 of 2022
Yes.
was filed for violation of which order?
Violation of a first petition and as well as the first contempt order. They are not compliant. In the second contempt, what happened? The London additional government advocate has submitted the the order has been complied falsely. Because yes. Because on the administrative file, on page 27, you also can see that is letter number 105 and 4/1/2023. Basing upon which letter the London additional government council has submitted before the honorable court. Can you see that letter last? As soon as the necessary clarification instruction is received from the government, you will be implemented accordingly. However, the undersigned, that is container, will be pursuing hard the matter before the government for early disposal of your grievance. Based on that letter, he has submitted and the second contempt.
But your petition was dropped. Still, Mr. Please examine.
Please to drop the contempt proceeding and given liberty to approach while filing the application.
Let's see. I am taking a different approach altogether for the reason that here is a case where he says that he has been working.
Yes.
And you are not in a position to pay because the source from where you are getting the fund is no more available.
Yes.
The fact remains that you had taken work from it.
Yes, services is being taken on board.
Yes.
So whether you have been paid for that service, I'll have to say, I'll get it. Yes.
And their objection throughout, they have stated.
Please wait. As this matter on 4 weeks, so as to enable learned counsel for learned HBA representing the contenders to seek instructions. We are not saying anything.
That's what I'm to I will see that it's paid to him also.
My lord, for the last 6 months, they have been taking time on the plea of this concurrence. You also grant some time, but that
1 week?
2
weeks. Okay. As requested on by learned AGA representing the contenders. This matter on 2 weeks. So if on the next date your matter is not taken up, just make a mention.
Madam.
All right.
I'll make it. Okay.
162.
Yes. Well, for the estate.
Yes, I have got the instruction that the order has been complied with and he has been paid the area salary deducting the amount which he has already received. That is instruction dated 19th of April 2024. Now.
There is no representation on behalf of the petitioner. When counsel, when AGA representing the containers has submitted based on written instructions which he has received, that this court's order dated 6/3/2023 passed in WPC number 36335 of 2022 has been complied with in as much as what has been done?
No, sir. It is stated that as per the direction of the court's order, the scale of pay admissible to the petitioner as junior clerk has been paid, deducting the amount already paid to him.
Repeat. Please repeat that.
Yeah, lost me. Only 2 lines.
In as much as. Minimum scale of pay as admissible to the post of junior clerk cum typist has been paid to the petitioner, deducting the amount already paid to him. So the contempt sitting stands stopped accordingly.
163.
Lord, item 160 kindly considers infructuous.
164.
Bless.
May I please, sir? And the order at annexure 1, page 6, and the relevant portion is page 8. May I place it, sir?
Please, please. Page 8, yes.
Page 8, my lord. Upon a careful consideration of the actual background as well as the documents placed before the court, after I am going through the order dated 25/11/22 under Annex 1, this court is of the considered view that once the petitioner as a candidate submitted his application along with documents, the duty is cast upon the BO to verify the same and put his signature on it. Therefore, the failure on the part of the block education officer to countersign in the mark sheet cannot be a ground to deny the petitioner of his legitimate right to be considered such appointment. In such view of the matter, the approved order dated 25/11/22 under Annexure 1, according to this code, is unsustainable in the eye of law, and the same is liable to be set aside, and the same is hereby set aside.
After disposal of the writ of appeal, the CDM had written to the government that either you grant permission to comply the order because amount has to be sanctioned by the state government, or you file SLP. So that is the so-called filed by the CDM members of the
It is not amount, it's appointment.
No, this is something else.
So, Losina, only next week only, Losina, what has been done, I will get it, Loss, next Friday.
May second order, may I place here? Second order at page 9 in contempt, my lord. Para 3, considering the submission made and as a last opportunity, the court deems it proper to provide as a last chance, and the contempt petition stands disposed of with a direction to the opposite party contender to comply with the direction of this court dated 18/1/2023. Well, this is the advertisement of 2016 for the post. After several approaches, this honorable court directed to post them. The advertisement was for 75 posts. 54 posts were they got appointed, but this was done despite of several directions not appointed. Then, my lord, opposite party contender to comply with the
Whether the
directions
compliance.
of this court dated 18/1/2012.
Yes, sir. Writ appeal was filed. Writ appeal came to be dismissed in December 2023. Lordship. After this order, my friend was showing to Lordship. Whereafter writ appeal was dismissed. And subsequent event, I will obtain instruction only next week.
That's so good also there. The writ appeal dismissed. We have written to the state to allow us to file the SLP. That letter is of 2000, December 23, my lord. In the meanwhile, 6 months elapsed.
ठीक है, ठीक है. 4 weeks. But 4 weeks.
2 weeks after, 2 weeks after, my lord. It's a very old matter, my lord.
Yes, yes, we are also concerned about this. Is not very old matter.
Advertisement of 16, my lord.
Advertisement is of 16, but this contempt is of 2023. We'll see.
Item 165.
Page 36 candidate yes. Paragraph 15. But order has not been complied. For the foregoing reasons thereof, the writ petition is allowed, the open order and unnecessary rulings were set aside. The opposite party authorities are directed to take steps to grant pension and proceedings.
165.
Where is the order?
Page 36, madam. Paragraph 15. The opposite party is authorities directed to take steps to grant pension and personal benefit as admission law to the petitioner without any further agreement in any case not later than 2 months, madam. And it was passed in the 10/5/2023, madam. But not yet complied till that one. Even SLP has already dismissed against the order.
Yes, I filed a complaint affidavit. I've given a copy to my friend also. My friend is aware that person to that was. He has not, so now the government has issued the sanction for not pay all pensionary benefits.
So that is next week, the next Friday, you also put it.
Sir.
Next week, as requested on behalf of the petitioner. To consider compliance affidavit.
Yes, compliance affidavit filed today.
Compliance affidavit. Yes, this matter on. Fine, so.
Next
Friday.
166.
May I please, your lordship? I'm in the PC mode.
Yes.
This is a matter of RA scheme. Order dated 7/8/2023, yet not complied.
Yes.
Yes, we have preferred writ appeal number 220, 244 of 2024 laws.
It has not been yet listed.
Yes, not yet listed, but we have already approached the lawsuit.
Appeal have filed. No contempt is made out. The petitioner has alleged disobedience of this court's order dated Seven, 8/2023. 6/12/2022, passed in WPC number 27479 of 2022. Stop. It has been stated by Mr. AGA, learned AGA representing the contenders that a writ appeal has been preferred against the said order of this court dated 6/12/2022, registered as WA number.
Yes, 244 of 2024.
244 of 2024. So, as the contenders have preferred an appeal against the order violation of which is being alleged in the within contempt application comma, no case of deliberate willful disobedience is made out or stopped. The contempt proceeding stands stopped.
167.
Petitioner before your lordship is a retired employee.
Yes, sir. Here I would request the lordship, grant me sometime I obtain instruction that regarding deduction during termination week, it has been said that amount is also grant me sometime after the instruction.
Weeks.
Yes.
As requested by AG.
But to comply the order dated 15/3/2022, my lord, in the contempt application, there was an order. In the contempt proceeding, my lord, there was an order dated 15/3/2024 that they are asked to comply with.
They'll do it. They'll have to comply with that. Your
168.
168, the operative portion is at page 22.
Paragraph 7.
Having heard learned counsel for the parties and taking into section account the provisions contained in the section 10C of the Odisha Education Act, vis-a-vis rule 83 of 74 rules, as well as decisions as cited supra, this court, while disposing the writ application, reputation directs the OP number 1 to take immediate steps for constitution of common cadre as provided under section 10C of the Act, read with rule 83 of the rules within a period of 4 months from the date of receipt of the order. On the last occasion, that is on 26/4/24, they had filed an affidavit along with some documents in the seal cover, which is with your lordship, and they had paid for further 3 months' time to comply with the same. That 3 months is also over, your lordship. The affidavit dated 21/3/24 is flag C, your lordship.
Today, that is the some more time I will because the last seal cover it was provided to the honorable court was. And the draft everything. I will see that in the meantime it is worked out. Sometime may be given.
No, there is statutory requirement, and then there is direction, but also by this court. Why will you not do this?
No, because there are more than 6,000 senior lecturers whose graduation it has been prepared for promotion to the post of principal of different colleges. So there are some verification process and time was required. That is why it was stayed with your lordship for 3 months. 3 months is over exactly today. So I pray also grant me a week or 2 weeks time so that I will find out.
This is something else, Mr. Are you making your submissions in 8037?
8037. 8037.
8037 something else. Compliance of the provisions of section 10C.
Yes, my lord. That is quoted in the order.
What is section 10C?
Not that
10 capital C.
My lord. Yes, sir. 10 capital C. Also true.
That is constitution of common cadre and its consequences.
Oh, constitution of common cadre.
My lord. That is page 150 of the book.
Oh.
Because
right from your lordship 1974
it is mentioned common care, therefore. The order, therefore,
my lord.
Because
common cadre.
Common cadre.
Cadre, it's right
from 1970.
Just a minute, just a minute. Where is that? 83?
977. Page 977. 978 is 83. 978.
Nine
977 is section 8 only. 978 is 8 vacancies in the post of.
And when was this order passed?
In May 2023, 11/5/23. And from 1974 till date, a common cadre has not been constituted till date. That is why this direction was issued.
Yes, Mr.
So I'll find out because the draft proposal was ready with us. That is why affidavit. It was sent to the GA department for waiting. I'll find out whether in the meantime it has been worked out or not, bro.
How much time?
2 weeks time only, I'll see that in the meantime.
Is this matter? 1, 2 weeks. So as to enable an LGA to seek instructions as to whether common cadre in terms of the provision under section 10 capital C of the Odisha Education Act and Rule 8 bracketed 3 of the Odisha,
page 976.
Education.
Odisha education bracket recruitment and condition of service of teachers and members of the staff of aided education institution bracket and rules 1974.
RCT, RCS, TMS, AIE rule 1974.
My lord.
Or not. Or not. Yes.
169.
Please, Your Lordship, the non-compliance of order dated 18/4/2023. The Lordship starts from page 6. The Lordship, Annex 1, operative part, the Lordship, that is page 8, Your Lordship, for the grant of compensation under rehabilitation and petitioner has been called for the document during the order hearing. The Lordship at page 8, Your Lordship, operative part, para 5. Considering the limited nature of submissions without expressing any opinion on the claim of the petitioner, this writ petition stand disposed of with a direction to the opposite party number 2 to consider and dispose of the representation of the petitioner as at Annexure 3 within a period of 4 weeks from the date of communication of this order or production of its certified copy, whichever is earlier. It is needless to mention here
It has not been done.
Pardon, Your Lordship.
The representation has not been considered.
No, Your Lordship.
It has been considered by the order dated 23rd of February 2024. It has been considered and disposed of. It has been communicated to him also. Personally, I will get this order. I can give a copy to my friend also.
It is stated by AGA representing the contemners that in the light of this court's order dated 18/4/2023, passed in WP C number 29113 of 2023 at 22, petitioner's representation has been disposed of by an order dated
23rd of February 2024.
23 to 2024. A copy of which has been communicated to petitioner also. Stop. Next, let a copy of the said order be served upon learned counsel for the petitioner in course of the day. So in view of the stand taken on behalf of the contenders, the contempt application stands wrong.
170.
Please, my lord. My lord, yesterday they have rejected my representation. That is complete. I will challenge.
It is an admitted position that in compliance of this court's order, the petitioner's representation has been disposed of. So, as the petitioner's representation has been rejected, learned counsel for the petitioner seek liberty to question the correctness of the said order by similar matters. Said order before appropriate forum in accordance with law of this application. Is accordingly, the contempt proceeding is stopped. Brought with the liberty as sought for on behalf of the petitioner.
171.
Yes, in this case, in similar matters, SLP has been preferred this honorable court has been pleased to issue notice and granted interim order.
In the present case, my lord, government has preferred writ only has been dismissed, my lord. But related not complied, my lord.
No, but
similar case, my lord, benefit has been extended.
No, but
in other cases, my lord.
And there is an interim order.
My lord.
Then no contempt.
In the present case, in other case, my lord. In other case, benefit has been given.
Mr. Counsel, we are hearing your contempt application.
My lord.
So whether the disobedience is willful or not,
my
can they obey the order today?
My lord, my lord.
Whether they can obey the order today. In contempt application arises out of an order dated. Which order?
8822, my lord. Annexure 1. A container will lie over, my lord, after this. Container will lie over, my lord.
Container?
Container will lie over, not.
He says that contempt was
despite the order of the hard zone of the petitioner, my lord, is not getting pension, my lord. It again he will approach.
Out of an order dated 8/8/2022 passed in WPC number 7806 of 2022, passed by a learned single judge of this court. Stop. The petitioner has alleged disobedience of the said order. Full stop. This is an admitted position that an intra-court appeal referred against the said order came to be dismissed by this court by an order written.
Order 12/10/23.
12/10/2023. Passed in WA number?
WA number 691/2023.
691 of 2023. So, the state of Odisha has preferred an SLP against the said order of the division bench.
Not preferred SLP in this case. In this case, not preferred
similar cases.
Oh, no. This case, in this case, no SLP preferred.
No, my lord.
Yes. What is the Supreme Court stated that they shall be, the person should be allowed to receive their pension amount, but the order will be stayed. So they will be given pension because the order will
no, whether the
not in this case, not.
In this case, no appeal has been preferred.
That is because also I will because the order of the Honorable Supreme Court has been given to me. Whether the particularly 71 or 72, you also may call it next Friday. I will obtain whether
specifically next Friday.
Here,
The accountant general was included as OP number 6. I think there is no cause of action against the accountant general.
2 weeks and requested on behalf of the estate. Yes.
172.
Later.
72, sir. 173.
Now, we are going a direction to dispose of the representation. 2024, also grant type that covered by also yesterday's order. We'll also call it after 5 weeks, so we'll maintain do it.
5 weeks.
174.
State has to file a complaint report, my lord. Yeah.
Complied with. Order has been complied with or not?
No, they have first complied, rejected my grievance. They have withdrawn that letter and submitted that to file further complaints report. I order my lord 19/4/2024 में कायल पे order number 19/4/2024.
Yes. Yes.
Plus, pursuant to the subsequent, only I filed that compliance affidavit was in February 24th by passing the speaking order. But now, I find the lawsuits have been placed to direct on 19/4. I will take instruction in the meantime because the order is not clear in my file or the order. Also calling next week only, I will find out the loss.
2 weeks. As requested.
175.
$90. For non-compliance of order dated 24/7/23, page 32. Operative portion is page 34, my lord. Page 34, para 8 and 9.
Yes.
Direction to release my unpaid salary, my lord. From August 2022. Yes, I found the paper affidavit and first content was disposal of my lord at page 13, page 14, 19/10/2023. Yes, what is the first content was disposed of?
No, forget first content. This come to paragraph 9.
Yes, I will give a finding today by so-called affidavit is in 5 years. We have approved the Honorable Supreme Court in SLP. That's why I am given the paragraph 7 of the so-called affidavit. My lord, so far as this case is concerned, they have not able to Honorable Supreme Court. But against the first case, Annexure 1 order directing to regularize since similar situated person have been regularized. They filed writ appeal was dismissed. Against that order, they went to Honorable Supreme Court. Subsequently, they, after receiving the regulation order from this Honorable Court and contempt order, not
what will happen if they succeed?
But
if they succeed, then what will happen?
My lord, what I am getting before the order, at least I should be paid my salary. How I am surviving, my lord? Since I am continuing, therefore, Honorable High Court directed for unpaid salary, at least those on what basis, on basis I am getting previously before that order, that should be paid. Therefore, this Honorable Court directed to pay the unpaid salary. If they will succeed, they may not regulate my services, but my present salary.
But this is what we are, the question, the first question is that if they succeed in the SLP, then what will happen?
Services. In first case, direction was to regulate my services. Against that, they went to they find the writ appeal was dismissed and against that they went to Honorable Appeals Court. After receiving the order,
from this honorable court, against regulation and contempt, it is did not release my salary, what I am getting before the order. Therefore, I second time we filed with petition to release my at least salary, what I am getting prior to order. And this honorable court directed to release my salary.
Prior to which order?
No,
To the order of learned single judge.
no.
Yes.
The paragraph 8, I have given the explanation. Our specific case is that he was never engaged under this division, he is not working. So that order of regulation will challenge the now he says that his salary. And our specific case is that he has never been engaged under any division of the organization destination. That is a specific so-called before worship. Have
you challenged this order? This order of the learned single judge. 24/7/2023.
No, sir. Well, that instruction, whether any writ appeal has been filed in that case or not, I will find out because in the against the original case, simply it will be thought, but subsequent for areas because there the first case was there was claim for regulation, so also payment of area salary. That was disposed of. And subsequently another regulation will filed for claiming only salary loss. So this is the present case where direction was given to pay the salary loss. It is from August 2022. Prior to I was paid my law. Also call it next week whether there is writ appeal or anything will
is that again, this is a case where the order was passed on the very same day when it was taken up. Without
government was hard minded. With due respect.
Hard on what? Hard based on nothing. There was no affidavit. And had there been an opportunity, they might have taken the stand which they are taking now. Disposal of the writ application on the same day becomes very difficult for. Because there is, in that case, there is no adjudication.
In first case, adjudication was there.
First case, there was adjudication.
You have never stated that I am not working. In the counter, they filed matter.
Maybe, but
what is taking different stand? First case, your lordship kindly disposed upon 21/10/22. There is 11 matter.
All right, you do whatever you want to do. You are not, you could have filed a review, you could have filed anything. Just this matter on 4 weeks as requested by AGA representing the contenders.
176.
Next Friday, I will take the fresh instruction whether the order is
as requested on behalf of the prisoner.
complied with
Friday.
177.
Please, my lords. Order dated 17/23, annexure 1, page 7, has not been complied. The opposing party is page 13, my lord. Paragraph 11. To set aside the order on termination and direct infringement. And the opposite partner, the opposite sole opposite party, he has filed the petition before my lord for grant of 3 months' time. That is on 25 March 2024. The court for 3 months time complied the order. Till that, not complied.
They will comply that by 26th of March.
They have paid for them when law already been passed. When you file the petition.
Yes,
Complied.
Not so I have got the instruction that we will comply within 15 days, but today's instruction we will comply the order of the lordships within 15 days because there is an opinion from your department that no appeals are live.
As requested on behalf of the contenders by learned AGA, this matter on 2 weeks to report full compliance of this court's order, violation of which has been alleged in the present contempt application.
178.
My lord, compliance order 21/6/2022, my lord, running page 16. Page 16, my lord. In view of the opposite facts and circumstances, the present petition allowed and the opposite party are directed to grant similar advantages of
So the petition as has been done in the case of North Supreme by the order so and so, the petition and against the order of this English government has preferred writ appeal. Despite the dismissal of writ appeal, till yet petition has not been given benefit.
Also, lost of admit time appeal instruction box last.
4 weeks request.
179.
My lord, petitioner applied petition for rehabilitation assistance scheme as per petitioner applied this petition for rehabilitation assistance scheme under rehabilitation assistance scheme appointment, my lord. And they, my lord, they have filed a affidavit. The government filed a affidavit which I have objection, my lord. I have filed their yesterday, my lord. It may not be there, my lord. So it may be next week.
Whether the order has been complied with or not?
No, my lord, not complied.
So what is the order?
Order was that the petitioner has been directed to file the rehabilitation assistance scheme application as per press rehabilitation assistance scheme 2020, whereas I have applied under 1990 rehabilitation assistance scheme, my lord, and the
page 5, paragraph 6 of the order, towards the end.
Where is the order? Paragraph
6, towards the end.
No, where is the order? Order in the contempt petition.
The order I am telling you, that is the order passed by the Honorable Single Judge, which is sought to be punishment on this contempt bill.
Yes, but where is that order?
Page 5 bills of the
page 5
contempt petition, paragraph 6 towards the end. Last 5 lines of the towards the end bills. It is needless to mention.
Paragraph, page
5, paragraph 6.
Yes, considering the submission, it is needless to mention.
Towards the end, it is needless. 5 lines from the bottom.
Yes.
It is needless to mention here that the application of the petitioner shall be considered and disposed of by passing a speaking and reason order. Any decision so taken on the representation shall be communicated to the petitioner within 2 weeks. And that has been done. We have filed the complaint affidavit that in the meantime we have passed a speaking order.
We'll also have a glance at starting of the para 6 of that order, my lord. Considering the submission made by the respective parties, this court disposes of the writ petition at the stage of admission with a direction to the opposite party number 2 to consider the application of the petition under Annex 4 series and dispose of the same expeditiously, preferably within a period of 3 months from the date of production of certified copy of this order. Further, it is directed that while considering the application of the petitioner, the opposite party number 2 shall take into consideration the law laid down by the Honorable Supreme Court in the case of Indian Bank versus Formula, such and such that has been basing upon the 1990 rehabilitation assistance scheme, my lord.
You can challenge that,
my lord.
It's very difficult for this court to hold that the disobedience, if any, is deliberate or willful.
That is deliberate, my lord.
How?
My application is under
your application was directed
1990, my lord.
Your application was directed to be disposed of. That has been disposed of. If you say that the order is illegal, therefore contempt, then that is not acceptable.
My lord,
by an order of this court.
I have filed a reply to that if that affidavit. That may be.
You can challenge that. Don't waste time in pursuing this contempt matter. You should challenge that order if you are aggrieved.
That liberty may be granted.
That liberty I'll give you.
How will I smell?
This court's order dated 22/12/2022, passed in WPC number 34356 of 2022, has been complied with in as much as the petitioner's representation has been disposed of. London Council appearing on behalf of the petitioner has, however, submitted that the order which has been passed disposing of the petitioner's representation is not in accordance with law. And therefore, the same cannot be said to be in true compliance with the of this court's order. So, next, since pursuant to this court's order dated, what is the date of the order? 22. Since an order has been passed on the petitioner's representation as directed by this court dated 22/12/2022, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped. However, the petitioner will be at liberty to question the correctness of the order passed on the petitioner's representation before appropriate forum in accordance with law.
180.
In this case, my lord, they have not complied yet.
Yes, I have complied the order, passed the order. My friend may be given the copy because we have considered that dispose of the representation by the order dated. Yes, 19/6. Yesterday, the day before yesterday, order has been passed. I'll given a copy to my friend.
Yes, ma'am. Complied with?
Just now, got my lord. The order has been.
Is stated at the bar. Now, it is stated by learned AGA that this court's order violation of which has been alleged in the present contempt application has been complied with, and the petitioner's representation
Rejected, I will challenge. They have rejected, I will challenge.
disposed of by an order passed on 19/6/2024, a copy of which has been handed over to learned counsel for the petitioner in the court itself. So, in such view of the matter, the contempt proceeding stands stopped with a liberty to the petitioner to question the correctness of the order passed on the petitioner's representation.
181.
Yes. Yes, Mr. Sam.
Yes, order has been complied with and the amount has already been paid to the petitioner. I've got the recent instruction dated yesterday. Amount of rupees plus 58,375 has been paid to him.
Yeah, please give us. Learned AGA appearing on behalf of the contender has submitted that this court's order has been complied with. Court's order violation of which has been released in the present contempt application has been complied with. But this is requisition of amount.
No, last page here was there is a requisition and financial form rule 18 was. This has been done by the executive which has been advised to be paid to him.
Complied with, and the petitioner has been paid an amount of rupees 58,375 on 26/2024. So, next, in such view of the matter, the contempt proceeding stands stopped.
182.
My lord, in this case, they have allowed the representation and I got all the things.
Complied with.
Item 183.
Now, during pendency of the contribution, they have already rejected my claim, my lord. Also, liberty to kindly file a fresh writ application.
Yes.
So, like
184.
My lord, 184 papers no time. 1 week time may be given. 1 week time.
You want time? My friend wants time also, I don't know.
What do you want? Whether you have received any instruction?
Yes, I filed a so-called affidavit since 16/4/2024, so-called affidavit.
Complied with.
I'll give a copy to my man. He said he has not received that.
So whether it has been complied with?
Because,
Yes, see, yes.
so we have stated that to us, because losses,
I will reply file, my lord, copy.
no, say another writ application, there is an order of stay that is on court below. There is an order of stay, it has not the same by a division, by order of this honorable court below. An interim measure directed that the selection process may continue pursuant notice, however, no final appointment shall be made. So on that basis, his order cannot be complied with now.
All right, give him.
I'll give him a
We'll take up. Friday, 20 requested. Do this matter on Friday.
185.
Order of my lord is at page 7. The relevant portion on page 8 last paragraph 6. Relevant portion page 8 of the content petition, paragraph 6. This honorable directed to consider my case in the light of the earlier orders passed in two similar cases, my lord. In Rabindra Kumar Jana's case and one Sotapagna Samo's case. Now they have passed an order rejecting those two cases which are relied upon by this court. In those cases, the government has not implemented, therefore it cannot be implemented.
No, what is the direction?
Direction paragraph 6. I claim for pension, my lord. Paragraph page 8, paragraph 6, last two lines. Having heard one counsel appearing for the parties and on careful examination of their submissions and on a careful examination of the background facts of the present case as well as the materials on record, this could.
So what is their stand?
Their stand, my lord, that those two cases were relied upon. In those two cases, the government has not implemented the order, still pending. Therefore, we are not implementing it. That is their stand is at part, page 11, my lord.
Yes.
As I will obtain instruction limited, I'll file a so-called loss program sometime.
4 weeks time is allowed for the foreign AG to file so-called reply on behalf of the contenders. So this is on 4 weeks.
186.
Lordship, the contempt of page 7, annexure 1, lordship, that is the lordship's order. See, matter relating to grant of pension and other benefits to Archer's employees, lord. Lordship, in the para 6 of my lord's order, lord, that may read the page para 6, page 7, the contempt petition, lord. But in view of the aforesaid limited nature of grievance of the petitioner, this court disposed of the application granting liberty to the petition to file a fresh representation if the opposite to includes grievance within a period of 2 weeks. If such representation is filed within the time stipulated, this same shall be considered and disposed by this said opposite to in accordance within a period of 6 weeks from the date of filing representation. Further, the opposite to is directed to grant similar benefit to the petitioner as has been done in the case of Lordship Pradhan by the order dated 11/29 passed in OA number 1189/26. The petition is directed to appear before the opposite to along with the certificate copy of this order, lord. So this is clear order, but the Lordship Pradhan is covered by my order, lord. And based on that order, that is the only controversial in Supreme Court also. And based on this order, 2 persons have already received the pension. Another person, some persons have already received. But the government was sitting title of the matter.
neither is sanctioning pension or anything. So what such employees that's already covered.
Yeah.
I'll find out as
4 weeks.
Let me fix it next that again. Within
4 weeks time then.
4 weeks time. Last time it was directed to take instruction on the same ground also. So
Let us see. Yes.
187. 187, my lord, on behalf of Mr. Naik, he is on legs, he is in another court, maybe taken on next Friday.
Yes.
Yes, I've got a instruction that was we have prayed for us some time to dispose of the demarcation case.
Yes.
There is a direction to the Tahsildar to dispose of the demarcation of land below. And when the contempt because he had prayed for some time, the Tahsildar Gorakhpur had prayed for some, I think it must have been done. They are also coming next week only because of the election.
Next week. As jointly requested. Yes, this matter on.
188. It's a division, but I think it is wrongly listed because last occasion lawsuits had taken up before lawsuit along with Justice Raman had taken up this matter on 3rd of May 2024.
34.
Yes, sir.
Huh?
188. 188.
188.
Yes, sir. It's a division bench matter, maybe.
Why is it a division bench matter?
No, lawsuits had taken up before the division bench.
It's a different thing, but whether the order was passed by the division bench.
Yes. It's a tender work lawsuit payment.
This matter before
division bench. Next week you will before lawsuit
bench presided over by the Chief Justice.
189.
189, my lord, on behalf of Mr. Patti, direction was to consider the representation of the petitioner till it not complied.
Yes, it has been considered and disposed of. I am giving a copy to my friend.
It is stated by.
Let us on next week, my lord.
Why? If it has been decided, then we are disposing. I am disposing it out. Whether it has been rejected or allowed. The light of this court's order, violation of which has been alleged in the present contempt application. Petitioner's representation has been disposed of by an order dated.
Order dated 16/5/2024.
16/5/2024. A copy of which has been served by learned AGA appearing on behalf of the contender, on learned counsel appearing on behalf of the petitioner. Next, since an order has been passed on the petitioner's representation as directed by this court, the contempt proceeding stands stop. And since the petitioner's representation has been rejected, the petitioner shall have the liberty to question the legality of the said order before appropriate forum in accordance with law.
190.
189 resolution. Well, this is a non-compliance of order dated 24/9/2021.
190.
Yes. I'm receiving a
complied with.
Direction was for disposal of representation.
Consider dispose of.
Order dated
18 June 2024, my lord.
18 June 2024.
My lord,
yes.
Liberty, my lord, if
liberty.
No, 18 June 24, this has been disposed of, but the writ application was earlier disposed of. We have disposed of the representation on 18th June.
Yes, so he will have the liberty to challenge that order.
Much obliged, man.
191. Name is your lordship. On compliance of order dated 5/9/2023.
191.
Yes, sir.
Yes.
Non-compliance of order dated 5/9/2023.
Follow the order.
Page 12, my lord. Para 6. Consider the representation of the petitioner. Thereafter file the first content, my lord. Another for 8 weeks time granted by the Honorable Court till today no action.
Yes.
Give me some time, your lordship.
2 weeks, 4 weeks time is allowed for your AGA. It's for an AGA to seek instructions as to whether this court's order violation of which has been raised in the present contempt application has been complied with or not.
182.
Order dated 14/7/2023 under annexation 1 has not yet been complied with. Direction was to consider the representation of the petitioner, my lord.
Lordship, the order has been complied with. The speaking order has been passed on 22nd May 2024, your lordship.
You have a copy.
I'll serve a copy, your lordship. I'll serve in the
If
meantime.
you have a copy, then you can give him a copy.
Yes, your lordship. I'll serve one, your lordship. We've been given an instruction as come, your lordship. I'll serve the copy.
You have instructions, not the order.
No, your lordship.
All right, next week.
They're not given.
As requested on behalf of the violent AGA, list this matter on 1 week, next Friday.
193. I know it is second contempt against the bank officers who is not under the control of the state government. The last occasion, this report directed to serve the extra copy. It is wrongly mentioned. So I may play the notice may issue to the bank, to the contemner bank.
Where is the order?
Order dated, my lord, the two order. The requisition order dated 4/8/2022, 8/11, and thereafter the first contempt order.
Forget for contempt. Forget for contempt order. Where is the writ order?
Order dated 13, page 13, my lord.
Page 13.
13 is the second, the first contempt order.
So, counsel, where is the order passed in the writ proceeding?
Writ petition, my lord. That is,
I do not see the order passed in contempt proceeding.
Writ petition order dated 4/8/2022.
Where is that?
That is annexation 1, page 8. The direction is, my lord, from page 10. The direction is, my lord, para 5. Since it is submitted that the claim made in the writ petition is covered by decision of the Honorable High Court of Delhi passed in WPC number so and so, it is observed that the said opposite party number 1, while taking a decision to petition the claim, shall also take into consideration the relevancy and effect to the judgment. The entire exercise shall be completed within a period of 3 months from date of receipt of the order. And that order not compliant, but first contempt was filed, and the first contempt order, never, that the 4 weeks time was granted, that was also not compliant.
It should not be complied.
That is the second contempt.
Never be complied with.
That the direction in the writ.
Where was the direction?
Direction.
The direction was to whom?
Direction by this Honorable Court.
Direction was to whom?
To opposite party number 1.
Opposite party number was not heard.
Opposite, for that reason, the Honorable Court kindly please notice.
Where is the question of notice?
Or your bank manager is not under the control of the government.
No notice was issued to the bank. The no counsel was appearing.
The general manager of Indian Bank, not under the control of the state government.
It is not the way.
The independent
Not the
organization.
way. See, you should be careful. While taking such orders, you should be careful. Otherwise, it's impossible.
So, my lord,
you file a writ petition tomorrow, a writ petition is disposed of against a person who has not been heard.
no, that is the, my lord, that is the disposal by the single bench.
All right.
My lord, may I place the single bench order.
Petitioner.
The order is, my lord, is the retired bank employee, class 4 employee of the bank employee. The union has a filed a writ application. It was succeed. Then direction has been given to the all the banks, national bank,
to do as per the judgment of the petition as well as which are confirmed by the re-appeal case, my lord, and also subsequent by the appeal court.
Petitioner has alleged disobedience of an order dated 4/8/2022, passed in WPC number 15361 of 2022, whereby the opposite parties in the said writ application were directed to take a lawful decision on the petitioner's representation. First off, the petitioner had also claimed that this case was covered by a decision of the Delhi High Court passed in WPC number 7571 of 2014. Full stop. It was accordingly observed in the said order that the OP number 1, while taking decision on the petitioner's claim, shall take into consideration the relevancy and effect of the said judgment. So, next, the fact remains that the petitioner had filed a contempt application 372/23, which
Order dated 1/12/2023.
which was disposed of by this court. By where is that order? Where is that order?
The order by
An order dated 1/12/2023,
15.
passed in.
That's a clear direction to comply with the figure of terms.
Stop. Next, the fact remains that neither the writ proceeding nor in the previous contempt proceeding the opposite parties were noticed. First off, both the orders were passed in their absence. First off, in such view of the matter, I do not feel inclined to exercise contempt jurisdiction for disobedience of the said orders. Stop. The contempt petition is dismissed.
194.
It goes without saying that the petitioner shall be at liberty to pursue his remedy before appropriate authority/forum in accordance with law.
194.
Like, Lordship, the matter has been complied with and the petitioner has been also communicated with the order, Your Lordship.
Complied with.
The order has not been communicated to the petitioner as on date.
He is saying to have a copy.
No, Your Lordship, you only have an instruction.
All right, next Friday.
Next Friday.
195.
Next Friday.
Next Friday. Why?
File this move.
Why next Friday?
To take instruction whether, because due to
Let us see what is the order.
Yes,
Where is the order?
Copy may also be served on us, Your Lordship.
Page 7, man. Page 7. So, to consider representation of the petitioner pass order.
Yes, this has not been done. This has not been done.
Instruction lagi छुट्टी पड़ गया
Requested on behalf of the petitioner to seek instructions, further instructions, this matter on. Next week.
196.
Page 13, relevant person, annexure 1, page 13, paragraph 6. The writ petition is therefore is allowed. Interim order under annexure 12 is passed. The opposite party authorities are directed to pass necessary order extending benefit of family pension to the petitioner in accordance with law. If there is no other legal impediment, having regard to the fact of the petitioner is an old lady, aged about 80 years, necessary order shall be passed directly within 4 weeks. Now, in their so-called, they have said that they will have filed a writ appeal. Mere filing of a writ appeal will not operate as a state. Well, this is the Supreme Court, Sanjeev Kumar Singh versus State of Bihar.
Yes.
Unless the appeal is listed and there is an interval, the appeal is not, writ appeal has not been listed. No interval passed. If relevant person, though such contention put keeping in view the provision contained in Order 41 Rule 5 of CPC, unless the appeal is listed and there is an interval, mere filing of appeal would not operate as a stay.
As?
Operate as a stay.
Not the question, Mr. The question is that when we initiate contempt proceeding, we do that only when we find that the disobedience is deliberate.
Yes.
So if an order is passed, they have two options, either to await or to challenge that.
Yes.
They opted for the second. They challenge that.
They have
the third option is that to disobey that deliberately, then contempt would lie.
There is no order in writ appeal.
No order in writ appeal. When was the writ appeal filed?
Government lawyer they have filed a writ appeal.
You must be knowing.
In a so-called, they have stated paragraph 5, my lord.
Yes. So if once they have filed,
paragraph 8,
that does not amount to a stay. That from that we can gather the intention.
Yes.
Whether the intention was to disobey or to challenge. So that option is there with them. The petitioner has alleged in the present contempt application disobedience or deliberate disobedience of this court's order dated 16/8/2023 passed in WPC number 22614 of 2017. So is next, it is an admitted position that the state of Odisha has preferred an intra-court appeal against the said order of passed by one single judge of this court, which is pending. Stop. Next, in such view of the matter, non-compliance of the order dated 16/8/2023 cannot be said to be deliberate. Stop. The contempt proceeding stands stopped accordingly.
One thing. You have to disburse of the pension amount subject to result of the return.
The best course would be that you appear in the writ appeal.
No notice has been issued.
Notice?
Not been admitted.
What is notice?
Writ appeal not been listed, not been admitted.
Notice. Tell the court what is Odia equivalent of notice. I will also know. What is the notice?
Order 5 Rule 20, my lord.
No, notice. What do you call a notice in Odia?
Summon.
Huh?
Summon
is again in English.
Odia also is a notice. Odia also is a notice.
In Hindi it is Suchna. Hindi Suchna. All right. Suchna means information. So now you have the notice. You have the information about pendency of the writ appeal. You can appear even without notice. All right. And then you can tell in the division bench that whatever
Well, 80 years old lady, her husband died in 79. 55 years in not getting pension.
Item 197.
97.
197. Will the order in respect of which violation alleged, Sanction 1, page 15. The operative portion of the order is at page 16 minutes. This is in respect of a direction for regularization of service of a driver who had worked for 20 years. So this is the operative portion of the order at page 16 minutes. In view of such position, the opposite parties are directed to regularize the service of the person within a period of 3 months from the date of passing of this order. With the aforesaid observation, direction will be allowed. When the disobedience complied, instead of filing a petition, contempt petition, person filed another request for a direction to comply with this order. That was disposed of. Can see page 26. That was disposed of on 1/8/23. With this observation, in such view of the matter, this court deems it proper to dispose of the writ application at the stage of admission by directing the Principal Chief Conservator of Forest, Bhubaneswar, Offence Paper 2, and the Divisional Forest Officer, Keonjhar, Offence Paper 3, to implement the order dated 9/6/21 within a period of 4 weeks from the date of communication of this order, and even the same has not been assailed and attains finality anyhow. They have not filed any writ appeal. After receiving this order, therefore, court has given them to file an appeal challenge which they have not done till 2023. They filed an appeal. And they didn't need the appeal. In the meanwhile, person was concerned to file this present contempt petition. Thus, you can see the order that will be passed by this honorable court in this contempt petition, present petition. Order dated 9/5/24. This is your lordship's record members. 9/5/24. And when minimal appeal has been dismissed by your lordship in last month, 17/5.
On the ground of limitation.
Members.
Limitation.
Members. That's what recalls that. So my last order, can you see Millers?
So when was that dismissed?
Dismissed. And now, can you see last order, members? However, as a last chance, again, in the content, in one repection they are giving time.
We understand. In fact, we also understand that in this case also, a direction for regularization was given on the very first day when the writ application was taken up. This is the practice.
No, but that was Miller. So that order itself shows, that in view of some certain position of law,
At least someone has the right to be heard. Even the estate has a right to be heard. There is a direction.
Filed in the IA, your lordship, where we've stated that after the dismissal of the writ appeal, we have issued a letter to the government, your lordship, on 7/6/2024, that is annexure B/1, where we've asked the orders for to give us conditions as to how we are going to implement the order, your lordship, to take
steps. What you can do, indicate that.
8 weeks time is allowed for the estate to seek instructions and file response. List this case on 8 weeks.
198. Let's keep the person will be government, the person will be there, person will be live over. But it's better manners. It's better the person is live over. Government take a decision within 2 weeks and communicate.
No. We are not disposing it off. This matter will come after 8 weeks. In the meanwhile, they shall file reply. This is how the proceedings take place.
8 weeks.
They will file a reply. Why? Do you have any objection?
I have an objection, but last order was, unless you can see last order, unless you perhaps seen it.
Please don't show me any order. Let it come after 8 weeks.
198.
Yes.
So which time may be given a lordship to file it?
On 99,
99 also your lordship, the same pertain to sales and matter to 4 weeks time.
item 200.
In 200, my lord, lordship kindly see improved order annexure 1 and the relevant portion of the order. Order means what? Judgment by directing the government to regularize my.
You are challenging that order.
No.
So only such orders are impugned which are under challenge.
Sorry, ma'am. The order is at annexure 1, ma'am.
Annexure 1.
The relevant portion of the order is annexure 19, ma'am. Last paragraph. I'm just reading, madam.
Page
19, madam.
19. Yes.
One. Last paragraph.
Yes.
Therefore, this court has no hesitation in coming to a conclusion that the petitioners are entitled to be regularized in view of the finance department resolution dated state. Accordingly, this court direct the opposite parties shall regularize the service of the petitioner in terms of resolution of essay against the available vacancy, including the.
Yes.
Lordship, 4 weeks time may be given to.
4 weeks time.
My lord, my submission, the petitioner will retire by 7th, my lord.
Retire.
Yes, ma'am. So after retirement, the judgment will become nullified because they say that there is no scope for regulation. Because order has been passed 2023, August. They are not complying. In the last date also, lots of directed to take instruction. I have served copies. They also kindly.
Please see what can be done.
Yes.
Item 201.
May I please? Hearing application has been filed for your lordship, then the content application has been dropped. To be able to provide, we are giving the compliance report to the court or to the petitioner.
What happened?
The compliance report has not yet been filed. Or not yet been given to the honorable court as well as the.
You'll
to the
actually file
petitioner.
complaints
In the meantime.
19.6.
In the meantime, yesterday you are filed an compliance affidavit and given to me, and my claim, the order passed by this honorable has been rejected. Your lordship liberty to challenge the same.
All right. Liberty to challenge.
Both the matters, sir.
Both have disposed of this. Both have disposed of this. IE order.
Just a minute. Which is disposed of?
01. Earlier to dispose of.
Then we are just. How can you file IA in a disposed of matter?
Because you are see.
All right, we are not saying anything. You will withdraw and you may challenge. See, I am not going to entertain your interlocutory application. It's a different matter that some order has been passed. Now some order has been passed. You can challenge that.
Yes, Your Honor.
That liberty I can grant.
Yes, Your Honor.
Anything else? Being stated by the counsel for the petitioner that we shall not be pressing IA number 387 of 2023 since an order has been passed on the petitioner's representation, rejecting the petitioner's claim. On when?
Provided my complaint secretary yesterday, Your Honor.
Stop. Seeks permission. takes liberty to question the correctness of the said order. So, IA number 388 of 2023 stands disposed of accordingly. Is it the same order 2002? Yes.
Item 202.
No problems. In this content, my lord, last occasion on dated 8/4/2024, my lord, the appointed by the consumer was filed in this case and brought 3 months time to file complaints affidavit as the general election is going on, my lord. And then even 2 months already over, the appointed party has to file the complaints affidavit by 19, it was last order, my lord. The order, order is at page 12 and 13, order dated 10/1/2019, my lord.
We have already filed a compliance affidavit, your lordship, dated 22/3/2024, your lordship.
No, that is not compliance affidavit, that is a time.
Yes, your lordship, because of the there were a number of enclosures, your lordship, and police force and all were required, your lordship, because of the ensuing elections and all, that was dropped in.
No, what was the direction of this court?
The direction was, your lordship, that under the OPLE Act to evict the encroachers, your lordship, in government land, your lordship.
Then, where is the direction?
And the forms have already been given, your lordship, to those encroachers, your lordship. They've been identified and forms have given, your lordship. Needs few more time to initiate all the proceedings, your lordship, because they're huge in number.
No, but still, where is the order which has been violated?
Your lordship, if I've quoted it in the affidavit, if you may read it over, that the Honorable Court, while disposing of the said writ petition number 19554 of 2018, was pleased to pass the following order of directions on 10/1/2019. So far as a case involving allegation of illegal encroachment at hand, finding and
No,
objection.
it seems I am seeing some other, is it 5091?
Okay. 3643, sorry.
36,
Just a minute, just.
202.
Yes, where is the order?
Order dated 10/1/2019 at page 12 of the content itself.
So which part has not been implemented?
Not eviction, my lord.
No, eviction, there is no direction for eviction.
So encroachment, all notice has been served, my lord.
Please come to the order.
Yes, my lord. That the inquiry immediately find out if there is an encroachment, fact or not. In the event it is observed that there is encroachment by anybody, the opposite party, number 4,000 to do initiating the encroachment proceeding and decide the same according to the law, my lord. But not decided.
That yet they could not evict.
My lord, how they will not evict, my lord, they are occupied, my lord, the government, my lord. My lord, it is the procedure, it is the part and parcel of the approval act that should be adjusted in the end, my lord.
Council, we are in contempt proceeding. The direction was to take a decision. That decision has been taken. The persons have been found to be encroachers. So that, to that extent, the order has been complied with. Now you are saying that the persons have not been evicted.
Right,
that was not the direction.
My lord, the result to be exercised, my lord. The result of the, my lord,
That's not the order.
my lord, the result, if the result will not be exercised, my lord, so how the petitioner will be.
That answer I don't have.
My lord, that is the duty of the state government, my lord.
What is, may not be answerable,
Yes, my lord.
to you, Mr.
My lord, my lord. Yeah, but it is the duty of the state government to admit them, because on.
That is different.
Yes, my
Duty
lord.
and compliance, these are two parts.
So for that, my lord, last occasion, the Honorable Court
No.
asked them to file a complaint. Affidavit to that effect, my lord.
Not it, not it. The petitioner has alleged disobedience of an order dated 10/1/2019 passed in WPC number 19554 of 2018, operative portion of which reads as under. Last paragraph. So far as next. After having heard learned counsel for the petitioner and learned AGA for the contemners, it appears that there is no dispute about the fact that proceeding was initiated for encroachment, for removal of encroachment in terms of the direction of the court, and further the encroachment proceedings have finally been decided. So, when counsel appearing on behalf of the petitioner encroachment cases, then counsel appearing on behalf of the petitioner has submitted that the contemners have committed contempt of court by not evicting the encroachers. First off, there was no such direction to evict the encroachers. First off, the Tahsildar has concluded the eviction proceeding by passing order in accordance with the provisions of what is that? OPL
Act.
OPED OPLED Act. OPLED Act. OPLE Act. First off, in the court's opinion, no deliberate disobedience of this court's order is made out on the basis of admitted position. First off, next, it goes, the petitioner shall, however, be at liberty to approach appropriate authority of the forum raising grievance regarding raising grievance, if any, relating to eviction of the encroachers from public land.
Yes, ma'am.
From public land in the light of the decision taken by Tahsildar. Tahsildar? Contempt proceeding stands.
Item 203. My lord, in this contempt petition, my lord, Annexure 6 is the order. That is page, running page 18, your lordship. Running page 18 of the contempt petition, my lord.
Running page?
18. Annex, in which the Honorable Single Judge directed, my lord, to release his admitted salary, my lord, in a IO, my lord. Since the salary was not paid, my lord, this contempt
and writ petition is pending.
My lord, writ petition is pending. Against the contempt petition, my lord.
So,
they file a contempt appeal, my
we
lord.
heard along with the writ petition.
My lord, they file a contempt appeal, my lord. Appeal and contempt order, that is the order dated 25/8/2023. And the appeal was dismissed. Thereafter, they carried to the apex court, my lord. Honorable apex court also dismissed the SLP, my lord. But they paid me arrear salary. But they are not paying me salary regularly, my lord.
Still, the order was passed on IA.
Yes,
Writ
my lord.
petition is pending.
Yes, my lord.
So the writ petition should be decided.
And that IA order, my lord, carried up to the level of the apex court.
Oh, sir, who is saying?
They are not paying me salary, my lord, remuneration. They pay me remuneration, which the honorable court directed, and it was upheld by the apex court. They paid me area, they play only after the order of your lordship in contempt, they are paying in phase manner.
Yes.
But I have filed the compliance affidavit and the petitioner was a Delhi wage worker. And prior to passing of the interim order, he was disengaged. But by using a slip, that is a ticket issued during COVID, he claims before this honorable court that he was working. That is why this honorable court has directed to pay him salary. But entire salary up to May 2024 has been paid. So Lordship may drop the contempt proceeding so that the writ petition can be heard.
No, but why will you not implement this?
I implemented. I have filed the compliance affidavit in February 2024 at my age.
They paid me salary up to, my lord, 15th May. Half month salary of May. Thereafter, they have not paid.
See, what is the order?
Page 18, my lord.
Yes.
In IU, my lord.
Yes.
Considering the submission made by the oppositor, this court in disposal of the I directs if the petition has been working from December 19th, admitted salary shall be released in favor of the petitioner by completing entire exchange within a period of 15 days.
So admitted by whom?
My lord, by the authority, I was working, my lord. So they paid, they didn't pay, my lord. That is why.
Do they admit?
Yes.
The direction is if the petitioner has been working
my lord,
since December 2019.
Yes, my lord.
Admitted salary 3. This is to be given. So everything is admitted.
Admitted, they paid me up to May 15th May 2024, my lord. Half month salary from December 2020, December 2019 to they paid me. But the continuous salary they are not paying, my lord.
You are not working, then how can?
Yes, my lord, I am never been disengaged. That has been dealt by the lordship, my lord, in order dated 25.
That is the question which can be decided.
That has been dealt, my lord.
Sorry.
And 25/8/2023.
The petitioner alleges disobedience.
And the disengagement order is not issued into me. And there is no disengagement order in my favor, against my.
The petitioner has alleged disobedience of the court's order dated 30/3/2021. Interview passed in WPC number 989 of 2020, which reads as under. It is not in dispute that the petitioner has been paid his salary from 2019.
December 2019.
December 2019.
Till May 14,
till May 2024.
24 as per the last order.
24. First off, the petitioners
still continue, my lord.
The petitioner's grievance is that he is not being paid his monthly salary.
Remuneration.
Monthly remunerations. First off, the in terms of the state order dated we do not find that in case of willful disobedience of this court's order is made out in view of the compliance affidavit filed, which has been filed on behalf of the. You are representing whom? On behalf of opposite parties number
2 and 3.
Not served on me.
2 and 3. Why have you not served?
Yes, my lord.
This is not the matter. This is the old one that has been dealt by this honorable court, madam.
No, no, that.
It is a problem.
Affidavit filed in the month of February. That is form, that is flag H. Well, Lordship's brief. Compliance affidavit filed by OP number 2 and 3 at flag H.
That is the old one. After the last order of the lordship, they are not filed a complaint affidavit.
Oh. Let the let WPC number 989 of 2020 be listed before the assigned bench on 6 weeks. Yes, your matter will be listed.
Malad, in read petition entry order is there. In read petition entry order is there.
Let the other connected method has been fixed to next week.
Which connected matter?
Let there are other employees in the same office.
Mr. The contempt petition I have dropped. Contempt proceeding. WPC is pending.
Yes, my lord.
WPC will be listed after 6 weeks before the assigned bench.
My lord, interim order to continue is there.
The other connected WPC are fixed to next week. May claim that may be
next week. Next week.
In WPC, my lord, if your lordship passing order in WPC, my lord.
No, we are not. I am not passing any order in WPC.
My lord.
Can we take up arbitration matters now? There are so many contempt matters. Arbitration cases.
215 complaint.
Please give. 215.
215.
215. Well, others.
Next Friday. Next Friday.
Next Friday.
Next Friday.
Next Friday. All cases next Friday.
Next Friday.
Is here. The person is here.
Government will also, this honorable court directed
223 who? Who is appearing in 223? Statement. State who is appearing in 223? Who is appearing in 223? Item number 223. Who is appearing? So there is personal appearance of some officer.
Yes, Lordship, but Ashwin, if next Friday, if it comes, Your Lordship, we all receive the files at 6:30 in the morning.
Please, all right. Please make a mention in the morning itself. In all cases where there is direction for personal appearance of any officer, please make a mention. I'll take up those matters first.
That officer should remain present also because your lordship already directed.
Yes, yes.
Item 212 and 213 is also personal appearance.
The Lordship, the officers will come to court or be on the BC.
I think you're asking here.
Next week. I will reflect there. He can join. The officers may join online also.
Ballot item 243. There were in the writ petition, disposed writ petition, I have filed an IA before the honorable single judge for modification. There is a mistake. So, but the file is there in the contempt. May I pray, my lord? I'll maybe illustrate so that I can take up. That will go. Because once it will be there in the list, my lord. The file I have filed. I accepted it here. It is sufficient.
Disposed of case. Disposed of.
That will go.
Yes.
Item 214. Yes, I am a petitioner. On a contemporary state file so called. I will file rejection affidavit, but rejection affidavit not attached in a file.
All right, it will be attached.
Right. Additional supplementary arbitration matters. Item number 1, ARDP 16 of 2024.
My lord, there is a provision for appointment of arbitrator in the agreement itself, but after repeated pursuance and different letters, there is no appointment.
Are you disputing this? All right. Matter on next Friday, responsible and counsel for the respondent to file counter affidavit if so required.
Item number 2.
Item 2.
Mr. Mishra will be correct. He is on his legs. Pass on.
Item number 3.
May I please, my lord, this is a petition under section 11(6) of Arbitration and Conciliation Act, my lords. The agreement is under annexure 1 and the relevant clause of invocation.
So they have been issued.
Pardon, no, my lords, notice has not been issued.
Issue notice. He accepts notice. I have to accept notice.
Item number 4.
This matter on how much time? 3 weeks time to seek instructions. And file a reply response if required. Yes.
Item 4.
May I please, my lord. Item number 4, which my lords, notice has not been issued yet.
Issue notice.
Item 4, 3 weeks. Item number 5.
No one appears next Friday.
Item number 6.
6, may I please, your lordship. Lordship, this is a matter under section 29A, your lordship. So there is a different view of Honorable Supreme Court, my lords. In that view, if your lordship may grant me liberty to approach the principal civil court of original jurisdiction in view of this judgment, thus I may withdraw this petition.
Then counsel for the petitioner seeks permission to withdraw this application filed under section 29. The 4 of the Arbitration and Conciliation Act with a liberty to approach the civil court, principal civil court of original jurisdiction. Seeking the same relief as sought in the present application. The said submission has been made in the light of a recent order of this court. A recent order of the Supreme Court dated 13 July 2024 in SLP civil number 105/44 10544 of 2024. With the liberty as sought for.
Item number 7.
My lord, item 5. I wasn't stay at this point. My lord, annexure 1, my lord. Clause number 93.0.
Item 5.
Clause number 93.0 is the arbitration clause, my lord.
Notices will go first.
My lord,
Notice will go first.
my lord.
Issue notice.
Item 7.
There is no representation on behalf of the petitioner. List this matter on next Friday.
Item number 8.
That notice of written as per the written on the list. We may certain new address and maybe notice may be sent second.
Notice.
But
Can present address. Yes.
but unutilized copy may be utilized. I am only having the total
Maybe you.
new address. My lord.
Item 9.
So if I may please your lordship, my lord, I'm appearing through VC. My lord, item 9, your lordship will see that there is a noting that inadvertently because we have not been able to file the postal requisites by 24/4/2024 and it has been filed on 7/5/2024. My lord, may I pray that that may be accepted and the fresh date may kindly be given for appearance of the opposite parties, my lord.
All right.
I'm extremely grateful, your lordship.
Requisites of notice have been filed on 7/5/2024, which were to be filed by 24/4/2024 in terms of the order dated 19/4/2024. Considering the submission advanced on behalf of the petitioner, that the requisites filed on 7/5/2024 based on requisites filed on 7/5/2024. Let notices be issued to one or more than one.
My lord, all the opposite parties.
The opposite parties. Yes.
My lord, a short returnable date that was to be fixed.
That date will be there.
Lordship, I direct for a short returnable date also. Kindly.
Yes, yes.
Item number 10.
Extremely grateful, your lordship.
It's item 10. I've filed an IA for impeding OMC as a necessary party. I've served a copy on my learned friend. My lord.
This is regarding what?
And it's an amendment application. Actually, we had made IDCOL Kalinga as an opposite party in the matter, but that has been amalgamated into OMC. My lord. OMC is to be made a party.
IA number? One has been filed for what?
And that is the amendment application, my lord. IA number 1/24, my lord.
IA number 1/44 has been filed. Seeking amendment.
My lord.
Seeking amendment, a copy of which has been served on learned counsel representing the respondent. The respondent today itself.
But we are the counsel for IDCOL.
Counsel for IDCO.
IDCOL, your lordship, IDCOL is amalgamated with OMC right now. Now, IDCOL has amalgamated with OMC. Right now, IDCOL has no legality right now, lordship.
So you are for OMC or IDCO?
Let's before that we are for IDCOL. Now we are for OMC as well.
What should I write?
That's your lordship may direct to file consolidated cost title so that we can ask for the wakalatnama from OMC. Although we have instruction.
In counsel for the Which opposite party are you?
Right now, Your Lordship, there is one opposite party, that is OMC, after amendment. Am I right?
What is your name?
Sucheta Guman Singh.
Also Cheta Kumari Singh. Learned counsel. Not saying anything. Is on when? Next week, I'll file the requisites.
Item number 2.
Pray for 1 week time to file reply.
I filed an application with
application.
jurisdiction. The maintainability of the petition, IA 17 of 2024. On the plea of territorial jurisdiction.
This is item number 10. Item number 2. Number 2. Item number 2. Fresh admission.
Copy served on the day of the filing, Milord. On 21st May, copy was served for him.
You are challenging the maintainability.
No, I am challenging
Yes,
the
filed an application.
He filed the arbitration petition. I filed an application challenging the maintainability, Milord.
Come this way, you. Yes,
So, as per the arbitration clause, as per the arbitration clause, it said, Milord, the place of arbitration was decided in New Delhi. So I filed an application that this honorable court does not have the jurisdiction on the 11-6 to pass any order.
So where is the arbitration clause?
I take 1 week time also to file a reply.
As requested on behalf of the petitioner to file a reply to the objection taken on behalf of the respondent in the point of maintainability of this application before this court on jurisdictional ground, list this matter on 1 week.
1 week. Publicly.
Specialist for orders item number 1, BMA PL 1367 of 2024.
Item 1 and 2. Item 1, 2 and 4 are same arising out of same PS case for 3 accused persons. Serial number 1, 2 and 4. But out of 2 are female serial number 1 is a female and serial number 1 and 4 they are the female person and another serial number 2 is the male person. Allegation that police getting information regarding transportation of contraband ganja, they enter into the bus, which is public carrier bus. In that bus, they found that 4 numbers of bags, that is mentioned in the FIR, 4 numbers of bag kept in the sleeper seat of a person. And on being asked, he disclosed his name as his name is Barun Banerjee. This is the petitioner serial number 2. Thereafter, those bags were discovered, and thereafter he disclosed the name of 2 ladies who are sitting in the another seats. Seat number that I'm reading. Is a flying bus from Kolkata to Chandigarh side loading contraband ganja. At this, I along with my staff rushed into the bus and on search found 4 plastic bags kept in the slipper beside a person who was found sleeping on the slipper. On being asked, the said person disclosed his identity as Barun Banerjee. Thereafter, he disclosed the identity of his accompanying members who are sitting in seat number 19 and 20, that is Ramsakhi Devi, who is in the serial number 4, and one is Luki Banerjee, who is the first petitioner. So this petitioner, there neither nothing was seized from this lady's petitioner. This contraband article was seized from that person. 41 kg of ganja mallet was recovered. Charge sheet has been implemented, charge sheet has been submitted. So I pray mallet, so that this petitioner number one, in the first petitioner mallet, this Luki mallet, nothing was seen from this possession. That was not, neither is kept inside it is a public area bus. And so other passengers were there. Nothing was seized from her possession, not from her seat mallet. It is admittedly it was seat from the seat which are sleeper coach seat which is occupied by that person.
How do you get over section 37?
37 because nothing is 37 when nothing has been seized from neither my possession.
Is there any NDPS?
My lord.
Yes, in fact, all these three cases I have received the case very recently. So I could not get time because I so like at 12 p.m. I got the records, so I could not get time. So last week I want to go through. I have got the case already.
All right, let it come on next Friday. Let the matters 1, 2, and 4. As requested on behalf of the state, list this matter on 1 week.
Item number 3.
My lord, this is a tired of matter, my lord. Out of 5 accused, 4 accused have been released by this honorable court. 4 accused has been released by this honorable court.
So offense under section 395. My friend says that out of 5, 4 persons have already been released on bail. Let me find out. I'll also call it also next week also now.
He have got the. I want to find the.
All right, let him see. He's seeking time.
Sir, already charge sheet is in file.
Next week only.
Because it is listed for the first time at 395. My duty is to implement them to get the what are the materials against him. Without going to
5 months he has in custody since 5 months he was in custody.
5 months, nothing. What is the sentence?
This is not nothing has been seized from this accused.
What is the sentence for 395?
10 years. 10 years.
10 years, and you were there for 5 months only. Nothing big about it. Next week. As requested by the AG, just the matter on.
Rest of the matters are for hearing, but it's item number 5 to 10 are for hearing.
Item number 5, may I please your lordship? Item number 5, my lord. The petitioner expert since long, my lord, the matter become infectious, my lord.
Infectious. Different counsel for the petitioner states that it is criminal division application has become infectious. So it is stands dismissed accordingly as having become infectious. Yes.
Item 6.
One appears dismissed.
Item number 7.
Dismissed. The petitioner shall be at liberty to seek restoration of the application.
Item 8.
No, first 6 and 7. 6 and 7. Right.
Item number 8.
Next.
Item 9.
825.
No.
8. Dismissed.
Item 9.
Time order.
Item number 10.
Time.